Good morning, all. This hearing is in the matter of CFI 046-2023, ENF 022-23, and ENF 023-2023, and is being held by way of video conference before Justice Sir Jeremy Cooke, with the sitting of the hearing taking place in Dubai. Any orders or directions made during the course or after this hearing will be issued by the registry in Dubai on the judge's instructions. The claimant is represented by El Tamimi and Company. Lead counsel is Mr. Carl Anderson. The first defendant and second and third respondent are represented by Seoul International. Lead counsel is Mr. Michael Patchett-Joyce. Thank you.
Yes.
Your Honor, I'm obliged for the introductions, and of course it saves me introducing both myself and my learned friend. Your Honor, there are three matters before the court today. The first I would propose to take is the application on behalf of R3, that is Ms. Mansour, and R2, that is RBM, Royalty Business Management, which is her company, applying to be discharged from the freezing order and for their names to be removed from the record. So ancillary matters consequent on the, I'm sorry, I hope the sound in the background is not causing any inconvenience to the court.
Not to me.
I'm obliged, Your Honor. That's the first application, and I'll come back to a preliminary matter in that regard very shortly. The second and third applications are much shorter. And
they're very short, Mr. Patchett-Joyce, because I'm not going to hear you on them.
Well, Your Honor, I'll seek to persuade you otherwise, but I'll come back to that if I may.
You can have two minutes to persuade me otherwise, Mr. Patchett-Joyce, but you know what the order was.
I do know what the order was.
There has been contempt. There is no suggestion that the prima facie jurisdiction of this court is involved, and that is the end of the point, isn't it?
Well, Your Honor, in relation to, let me take them very briefly now, seeing as they're troubling the court, and I should deal with them out of the order in which I was planning to deal with them.
They're not troubling the court at all, Mr. Patchett-Joyce, but there you are. You can have your 2 minutes.
I'm obliged. Your Honor, so far as the consent order is concerned, I accept that the first defendant is subject to a debarring order. But a debarring order does not, in our submission, mean that practice and procedure is just ignored wholesale. And he was, we say, or should have been, a party notified of the application for the consent order by the claimant and the second respondent. So it's not essentially that he is seeking to take proactive steps in the face of a debarring order. It is, if you like, the negative inverse of that, in that he should have been notified of steps taken against him because he was a respondent, he was named as a respondent, and he was not given notice of the application. So, Your Honour, our concern is, as I say, reactive and not proactive. And in those circumstances, we do say that it is right for him to be heard on matters of procedure in relation to the way in which the consent order was obtained. And Your Honour will have seen that I've gone into some detail, and I'm prepared to go into further detail in relation to what actually needs to be done under Part 23. It can be dealt with in short order, but in my submission, it does not go behind the debarring order because it's a matter of proper process in relation to something on which he was the recipient rather than the initiator. On the stay, Your Honour has already previously said, prior to my involvement, but I've read the transcript, that this is a matter of some complexity, and it undoubtedly is. When we get into the detail of the discharge application, there are many matters which need to be investigated. They're bristling with points of law. One matter is has been one relevant matter. The Invest Bank case has gone from the Court of Appeal and been argued in front of the Supreme Court in May, with judgment awaited from the Supreme Court in that matter. And of course, we have the case of Brodal to grapple with, which is a matter which we say is plainly relevant and that the court needs to take account of. In addition to that, we have a renewed a renewed permission to appeal application that was made and argued in front of Chief Justice Zaki Azmi on the 2nd of September. We're now, 10 days after that, and still awaiting the judgment on the permission to appeal. Now, one doesn't wish to count chickens, but the very fact that it takes time to decide does give us some ground for cautious optimism that there are matters which should properly be ventilated at an appellate level. That, of course, does feed into Brodel, but Brodel, for present purposes, is under the umbrella of the third respondent's application, but it may have relevance further down the line in due course. And there is a matter, a referral to the JJC, which again, Your Honour is aware of. The referral was made in January. And again, the indications are that a decision from the JJC is imminent and will be forthcoming sooner rather than later. So just to stand back from that background, the learned friend says that we have a high hurdle to clear in relation to a general case management stay. This isn't a general case management stay. It was specifically tied to the permission to appeal hearing and to the outcome of the JJC. Your Honour, if one wishes to look at it properly in my submission, it's essentially a timetabling exercise, a prioritization of what steps go when in what order, and therefore it's actually supportive of the overriding objective, both in the DIFC courts and of course in the courts of England and Wales. Now, how does one get that before the court when the client is subject to a debarring order? Well, we have to
comply with the orders made and purge the contempt, Mr. Patrick Joyce.
Well, Your Honour says that, but of course that is inextricably bound up. I accept that until a matter is removed from the court's jurisdiction, the court has jurisdiction. But Mr. Rashed has been consistently clear, and we will go into some of this in due course in the course of today. He's been consistently clear that the only asset within the DIFC jurisdiction are the shares in D2, and he has been consistently clear, and there is consistent support for his position, that the Dubai courts have said that is a non-executable asset.
Yeah, well, that's the ultimate question, which
yes,
of course we can't determine today, and which may depend on other people, of course. But you know, the bottom line point is, if the position is, as it now appears to be on the translated documents that I've seen, that the Dubai court says in terms you can't execute on the shares, the fundamental question is, does that make any difference to a money judgment that's now been recognized in the DIFC, where it can execute on any assets within its jurisdiction? And that's a fundamental difficulty. And that will all have to be resolved. And I, make no bones about saying that's no doubt raises very tricky, difficult issues. But the bottom line is still very clear, Mr. Patrick Joyce, and I'm simply not prepared to hear you any further, because your client was under an obligation to make disclosure orders of all his assets and has failed to do that. And his breach of the disclosure orders has been quite flagrant, quite deliberate, and long-standing in the face of many opportunities to repent and to come back and purge his contempt. In the absence of any purgation of the contempt, the court made an order, and in the result, I'm simply not prepared to hear you, because that's the terms of the order and it stands. So it's one application we have to deal with alone, Mr. Patrick Joyce, and I assume you want to get on with that.
I will want to get on with that, I'm grateful to the court for the 2 minutes that I've been allowed. In relation to the
a very long 2 minutes, Mr. Patrick Joyce.
My lord, before we do move on to that application, now that they are formally dismissed, I will make an application for our costs of those applications to be summarily assessed today. We have filed a statement of costs in respect of both of them.
Well, let's leave that till the end. Shall we leave that till the end, Mr. Anderson? I was conscious that you were likely to make such a request.
Yes, indeed. And then on the application to discharge the freezing orders, you will have seen that there is on the other side of the coin an application by my client to continue those orders. And as a matter of ordering the hearing, I mean, we're sort of in the court's hands, but it struck me that given that it is legally our burden to persuade you to make those orders afresh, you might prefer to hear me first justifying the orders de novo before hearing Mr. Patrick Joyce. But as I say, I'm in your hands as to which order you would prefer the parties to go.
Well, I've thought about that. I think it probably most economic to hear Mr. Patrick Joyce first. I mean, it's inevitable that having spent most of yesterday, well, all of yesterday actually, on reading the papers and reminding myself what this was all about, far more than the 3 hours suggested in the reading time, that one's come to some preliminary views about it. The key issue appears to me, and this is what I'd like both parties to address me on, is the question at the end of the day of the amenability of assets belonging to the relevant 2 respondents for execution now. The fact that they may have been embroiled, and indeed on the evidence appear to have been embroiled, in the whole of the management and affairs of the first defendant may very well mean that they have aided and abetted breach of the injunction and goodness knows what else. But that's not quite the point today. And there may indeed be a difference between an order for disclosure on the one hand and an order freezing assets on the other. Those are the particular points that I would like assistance from, having come to some preliminary views as to what the evidence shows.
Well, I'm very much obliged for that preliminary indication, and also I'm grateful to my learned friend for raising the proper timetabling. It's obviously a matter which could go either way, and it's right that the court should be consulted before we launch into the application. I'll turn to the particular key issue and give an a priori response in a moment. But before I do, my client has asked me to inquire of the court as to whether this hearing will be on a YouTube and therefore publicly available, or whether it will be treated as an interlocutory matter, where the practice of the court is not always, sometimes yes, but not always, to make recordings available. Now, the reason for the request, as I understand it, is because of what Your Honour will have read in her witness statements. She feels she has suffered personal harm, upset, and intrusion as a result of the worldwide freezing order. She says in one point, you don't know what it's like until you're subject to it. It has upended her life personally and professionally, and she does have a personal and professional reputation which she wishes to preserve. And in those circumstances, I know that assuming that it's exceptional, I'm taking that into account in what I say. I would submit that this is an appropriate application, not to be subject to public scrutiny by access through YouTube.
Well, it's an interlocutory matter, isn't it, Mr. Patcher Joyce?
Yes, it is, and therefore it is an exceptional application to ask for privacy, and I'm aware of that, and I've not been able to give the court any notice of it because I literally heard about it myself about 10 minutes before coming and joining the court this morning. So no discourtesy is intended to the court, no discourtesy is intended to my learned friend, but it is something that my client does feel very strongly about her personal reputation and wishes me to raise at the outset.
Mr. Anderson?
My lord, I think we would resist that. If Miss Mansour feels that strongly about it, it is strange in my submission that that application wasn't made formally to be determined by reference to the relevant legal principles about holding hearings in private. But in my submission, there is nothing in this hearing which is any different from any other freezing order application, and the default position is that justice must not only be done but be seen to be done. And in my submission, there isn't anything in what my learned friend has says that takes this case out of the norm and that justifies this hearing being heard in private rather than subject to public scrutiny, which is, of course, the default position in all civil proceedings. So I think we would resist that on the basis that it's not substantiated by any evidence or formal application other than a general feeling of grievance, which I'm sure every single respondent to a freezing order would feel. But that's never sufficient on its own to justify these sort of hearings not being heard in public.
Well, Your Honour, I hear what the learned friend says, but it does go beyond the general, and there is a very important specific point here.
Well, there's one point which I'm conscious of in terms of personal relationships that
that's what I was going to raise.
Need not be touched on at all today. I don't believe that formed any part of the court's reasoning, but and I don't think it need be referred to in any way.
Well,
I've got the point that you make about it, yes, which I don't think is a good point in the sense that I don't think it impacted on the court's reasoning, so that I don't think it needs to be aired today. And that, if that's her concern, well, I understand that.
That is her principal concern, and I'm sure that the fact that that the court understands the concern will be of comfort to her, and I will attempt to respect her circumstances and what the court has said. But, Your Honour, it does, in my submission, go a little bit further than simply saying, well, it's noted and can be left on one side. Because if Your Honour looks at the transcript of the ex-parte hearing on the 27th of May, we can do this, but I won't burden.
I've read it.
You've read it. And Your Honour will see that this point crops up round about, I think from memory, about page 18 of the transcript. And it was right at the beginning of, yes, I can turn the transcript up.
Yeah.
It's right at the beginning of the substance of the hearing. And therefore what was said, and which is really completely inaccurate, is a prefatory comment to everything which then followed. I'm just looking to see where it is. It's actually on page, yes, my recollection is correct. It's page 18 of the transcript, page 7041 of the bundle. And in addition to the point itself, it's when the point arose in the course of submissions, because in our submission, just reading the transcript, I wasn't there, so it's a matter of impression as far as I'm concerned. It certainly reads of a piece with something that conditions everything that happens thereafter. If the court or anyone else is seized of that misapprehension, then the court isn't even in a position to exercise mental gymnastics of putting it out of the court's consideration, because the court doesn't know that there are any mental gymnastics to be exercised. So what happened was this piece of information, which appears to demonstrate very close linkage between D1 and R3, is provided to the court. There's no one there to counter it because it's ex parte, and the court then holds that piece of information for the rest of the hearing, and that is our concern.
Well, I understand the concern, but whenever things are said to the court without evidence, the court is always very chary. And in this particular case, the evidence showed a close relationship in business terms, and indeed a close relationship, as might be expected over many years, with the family as a result. That's your own client's evidence. So whilst of course I can't, one can never say that something said didn't affect one's judgment at all in any way. I can tell you for certain that it didn't loom large, and that wouldn't have been the basis of any decision that I made. So well, I understand you've got a point in the context of sort of non-disclosure as well, but we'll come to that in due course. You can take it that I've got the point firmly in mind from that perspective. But really, the thing I want you to focus on is the amenability of assets for execution and the relevant test, and how that impacts. That seems to me by far your strongest point.
Yes,
because the intermingling, as I see it, of the accounts and the monies that has taken place, particularly as between RBM and HMR and Royal View, it shows simply that D1 used companies as vehicles, and as his personal assistant and power of attorney. Miss Mansour was extensively involved in making various arrangements and managing properties on behalf of RBM on the one hand, and HMR on the other, without necessarily a very clear distinction of roles. So intermingling, yes, you can take it that you've got a problem if you want to argue that there wasn't any intermingling. But where that leaves you at the end of the day in terms of the assets that are now available for execution is a different thing. And there may again be a distinction between RBM, which appears to have at least some assets, and your client whose assets are, on the face of it, personal only.
Yes. Your Honour,
when I say your client, you're representing everybody here, but I mean Miss Mansour.
Well, I'm only representing D1, R2 and R3, and there are others. Yes. But with that small reading into the record, I accept what Your Honour says, subject to one point, and that is in relation to whether D1 was acting through, other than on an entirely appropriate professional basis of professional services being retained and professional services being paid for. Now that, yes, certainly RBM, and because RBM was, if you like, the corporate vehicle of my client, Ms. Mansour, and because they were retained to provide property management supervision services on behalf of HMR, and that being Mr. Rashed's company, he ultimately was the natural person behind HMR, then to that extent, yes, absolutely. The question, however, if it goes beyond that, and the suggestion that somehow Mr. Rashed was controlling the whole thing, we don't accept that at all, because there was undoubtedly a long-standing professional relationship, but it was a professional relationship where, as I say, R2 took over from R1 in circumstances which have been again explained by Ms. Mansour. R1's bank account was closed down for sanctions reasons in 2019, so it couldn't operate. Leonard Friend has tried to build part of his case by saying, oh, well, this is all part and parcel of some skullduggery. It wasn't at all. It was closed down because of sanctions and the bank pulling the bank account. So in order for the properties to be managed and supervised and for the accounts to be continued, that is why RBM stepped in. But may I just deal with one loose end before I come back to both the key point that Your Honour has raised and my more detailed argument, and that is just to close off the in-camera application.
Yes.
Well, Your Honour, I'd invite Your Honour to rule on it. If Your Honour is ruling that it shouldn't be in camera, then Your Honour does have the point which is of principal concern, and I will endeavour to respect the anonymity of that particular point in the course of argument.
Yes. Well, it seems to me if I have to make a ruling, I have to make a ruling that the matter proceeds in the ordinary way, in the absence of what I cannot see as any particular grounds for the matter being dealt with in camera in breach of the ordinary principles of open justice. Where there's sensitive personal matters, this court is always careful that such matters are not given undue publicity, and the parties have already been told that I'm conscious of the point, and that it need not be addressed because it's already been addressed in writing. So the matter will go ahead in public, and I will bear in mind all that's been said in relation to points of sensitivity.
I'm very much obliged, Your Honour, and I'm just making a short note of what Your Honour has said. Your Honour, let me turn to the key issue, and that is the availability of assets now belonging to the respondents for execution. And Your Honour then said that my clients may have been embroiled. Embroiled is perhaps a slightly loaded word. We've explored that, and the relationship, the professional relationship of providing management and supervision services has been explained, and insofar as embroiled is an appropriate word for covering that, then that is the relationship between the parties. They were undoubtedly a provision of services by RBM and by my client as company secretary, that is acknowledged and indeed is fully explained in Ms. Mansour's evidence to the court. Your Honour says that we, i.e. the third respondent and the second respondent, may have, it may mean that those parties had aided and abetted the breach of the injunction.
Not a matter for today, however.
Well, it's not a matter, and we simply do not accept that.
Well, so I understand that. It goes without saying that you don't accept that, Mr. Patrick Joyce.
I'm happy to put down a marker and move on. And Your Honour also raised the difference between an order for disclosure and the freezing order. And again, if I can say a word or two before I get into the detail of this, so far as both my clients are concerned, leaving aside the first defendant, they have both provided details of their assets, and it was, I think, first in letter form, but it was certainly confirmed in affidavit. So Your Honour can see that Ms. Mansour has respected the court's order. Your Honour has seen the first affidavit from her which responded to the disclosure provisions. We can look at that in due course. We may well need to, because of course it's prayed in aid in relation to her second affidavit, which is relevant to the disclosure order. So she has made full disclosure of her assets, and they are not extensive. They are exactly as one would expect of someone acting in the way that she does, providing property management services to one main client and to other clients as well.
Could you? I'm sorry to interrupt again, Mr. Patrick Joyce, but I was unable to find to locate the disclosure order itself. It must be there in the bundle somewhere, but no one, I think, gave me a cross-reference to it.
Oh, my apologies. May I come? The disclosure order would have been made on the 27th
of May.
27th
Sorry
of
to
May.
interrupt there, friend. It's page 4707 of the bundle, if that assists, my lord.
Yes, thank you. That's exactly what I was looking for. But 4707. Let me just find that. A number of separate orders were made on the same day, weren't they? Or within a day or two of each other.
Yes, the disclosure orders and the freezing orders were made separately, partly because only disclosure orders were made against the fan entities, whereas the freezing orders weren't made against them. So they were included in two separate orders, which I think are back to back in the bundle there.
Thank you.
Yes, I'm obliged with it, friend. The material provision is paragraph 2 of 4709.
Yes. Well, the point that I was concerned about, and which you may want to address, although, as I say, it isn't a matter for today, is that the disclosure of her assets was only one part of the disclosure order. And certainly doubt has been cast by Mr. Anderson on compliance with other parts of it. Whether or not that impacts on the immediate question in terms of credibility or anything else, I suppose, is a matter upon which both parties may wish to address me.
Well, just looking at that, what she was ordered to do is set out in paragraph 2, and what RBM was ordered to do is set out, well, paragraph 2 relates to Ms. Mansour. Paragraph 3 is both Royal View and Royalty Business Management, which is perhaps slightly odd in that they are the shareholders are different. Royal View is D1, Royalty Business is R3. But in terms of what she was ordered to do, she's explained that she derived only she explained that she got nothing from D2, excuse me, and derived only salary from R2. She's not received anything from D1. She's provided details of the scope of her work as company secretary. The details of all leases executed with the second defendant. The second defendant is, of course, Mr. That is the company. That is the company of which she was company secretary, and she has disclosed further financial statements and all service charge records. So she has whether there's a formal the details of the leases. That is something which resides with the Dubai Land Department, and certainly details have been provided in that regard. And the total sums received by RBM or Royal View, we'll leave aside Royal View, RBM has again disclosed, because you have the full financial, you have the audit records and you have the financial records of the consolidated records. In our submission, you have everything. There isn't anything more to be disclosed.
Well, I'm sure Mr. Anderson will take issue with that, but I hear what you're saying.
Well, it may be, and I'm responding on the hoof. We'll go to the evidence, and we can see what the evidence comprises.
Yes.
But, Your Honour, dealing with the disclosure, my client, both clients, both Ms. Mansour and Royal Business Management, are in a very different category from the first defendant. And indeed, when one looks at the freezing order, they've made proper, in our submission, proper disclosure. Your Honour can now see what they've got. And the real test is whether the freezing order discloses any assets which are going to be susceptible to execution. And in our submission, that simply isn't the case because sorry, I've just given a page reference to Ms. Mansour's first affidavit. I'll come back to that. It simply isn't the case, and we'll have to look at Brodal here, because in Brodal, the company of which Mr. Brodal was 100% shareholder, its own assets were not amenable or susceptible to execution, and therefore the declarations sought by the claimants in that case were not forthcoming. Here, as we say in the skeleton argument, I'll come back to the paragraph in due course, it's a double problem for the claimant, because it's not the shares of a company of which the judgment debtor is the 100% or was the 100% shareholder. That is the relationship between D1 and D2. Here, we have a much more remote matter, which is whether there is any ability to execute against the assets of Ms. Mansour in person, or the assets against, or whether it is right to freeze the assets of R2. And what we say in paragraph 16 of our skeleton argument, which is on page 7198, we say it was incumbent on the claimant in the course of the hearing for the ex parte application to say what assets it says both R2 and R3 hold. And looking at the evidence, it cannot do so. We've provided the reference to the claimant's skeleton argument for that hearing. The claimant has not yet obtained evidence showing the payments of sums beneficially belonging to D2 from R1, R2, and or R3 after the imposition of the freezing order. So there's simply no evidence there. And of course, the
basic point, Mr. Patch-Joyce, that you have to grapple with is the transfer of the City Walk properties from D1 to D2.
Yes.
And I put it no higher than this, arguable evidence in relation to the transfer of the Polo properties, likewise out of the name of D1 into the name of D2. And then the intermingling of assets deriving from those in terms of rents and everything else, the income stream in the management of the properties, which have all been at one time or another in different accounts, first of all of Royal View and then of RBM. So that there is, and all one has to look at, as far as I recall the authorities, but you may want to take me to them, there has to be something that is susceptible of being utilised in the judgment, whether as a result of insolvency applications or otherwise. So that in one sense it's quite a low hurdle so far as recoverability is concerned, and the question of enforcement doesn't have to be shown to be clear beyond any shadow of doubt that what the other parties have is actually specifically the judgment debtor's asset, but the possibility of, or I've forgotten quite how it's put, a good reason to believe that, I think is the expression, isn't it?
Yes.
Something of that kind. So
the enhanced arguability test.
Yes, something of that kind. We'll come back to the exact details, but it's the intermingling which, on the face of it, creates the potential for that. And whilst one can't say with great confidence exactly what the position is, certainly so far as RBM is concerned, it appears to have been receiving money into its account of that kind. Now, where that leaves you at the end of the day, in terms of what money there now is, may be a different question. And that's why I say there could be a distinction to be drawn between actions in the past, which might or might not give rise to liability of some kind, not a matter for today, and the question of either continuing a freezing order or requiring further disclosure if it is said that the existing disclosure order hasn't been fully complied with.
Well, Your Honor, again, let me take the 2 points that Your Honor has raised in sequence.
Yeah.
First of all, the arguability about the or the transfer from the first defendant to the second defendant of the City Walk properties. The circumstances of that were obviously a matter between D1 and D2. And therefore it shouldn't rebound to the detriment of either R3 or R2. The actions of one party cannot be visited.
But that's not the question. The question is traceability. That's all. It's whether or not your client is. I'm simply looking at amenability of assets for execution at present, without casting aspersions on anybody in particular at this stage.
But on traceability, I think I can allay the court's concerns or anxieties in that regard, because the claimant has applied to the Dubai courts in relation to the transfer, and the Dubai courts have said clearly that the transfer from D1 to D2, because it was a gift, cannot be undone. And therefore, that's that, exactly.
Well, it is or it isn't. That comes back to our very basic question, which somehow or other will have to be resolved. Yeah, maybe onshore Dubai would do it, but if you've got we're back to this basic question that if the order that I've made stands, then the shares can be sold.
Yeah.
And the question is whether or not then any purchase of the shares will have confidence that they can get their hands on the properties which are in onshore Dubai.
Yes.
And therefore, what the onshore Dubai court would do in terms of recognition of any order this court may make. And, it's a minefield. Of course, it's a minefield.
It is. But Your Honour has anticipated the very point that I was going to make, that there is a very important distinction to be drawn between shares and assets. And sometimes, the court doesn't lose sight of this, but sometimes there is a blurring of the distinction so far as the claimant is concerned, perhaps for understandable reasons. But Your Honour is absolutely right. So what has happened, if one looks at that differentiation, all that the Dubai DIFC court has is jurisdiction over the shares in a DIFC company, which is D2. The jurisdiction over the assets, because the assets are onshore, rests with the Dubai court, and the Dubai court has been asked as to whether it will undo or reverse or whatever the gift, and it won't. So the assets sit clearly and unequivocally in onshore and in D2. So the traceability in terms of ability to satisfy the judgment, there isn't traceability. And that is now, I think, clear from the Dubai court jurisdiction. That's the first aspect. So far as the intermingling is concerned, I think there are two aspects here that need to be thought about. First, it's only intermingling in the ordinary professional sense of providing professional services by one party to another in respect to properties that that other party holds. So, and then receiving monies which were part and parcel of the audit reports and the financial data. But it wasn't the intermingling beyond that. The next thing that one must, in my submission, differentiate between is rental stream, rental profits, and dividends. Now, and again, we'll have to look at the evidence of all of this, but it's quite clear in my submission from what Ms. Mansour has placed before the court. There is a rental stream from the properties which have been tenanted either by short-term or long-term tenants. But that is only part of the picture, because there are obvious outgoings which are satisfying regulatory requirements, licensing, management fees payable to the DLD, etc. So the rental profits are very different from the rental stream. And again, there's been full disclosure in that regard by reference to the audited accounts and the external accounting material. The rental profits are actually non-existent because monies continue to be owed, particularly by D2, so that it is not as if R2 is a recipient of monies on behalf of D2. D2 owes monies to R2, and again, we'll see this in the accounting evidence, which is distilled in, I think, the second affidavit of Ms. Mansour. So, given that the rental stream is whittled away to nothing, the point that we make is there are no profits. And if there are no profits, there is nothing from which to declare and make a dividend. And that comes back, I hope, in answer to Your Honour's point about what is available and amenable to execution. Put simply, when you look in the cupboard is bare.
Now, you've made that point in relation to an order of the Dubai court, the cupboard is bare. The order doesn't actually say that, does it? The order simply dismissed the application.
Yes, but I accept that, and we can again we can look at the page reference. It crops up in Mansour's third affidavit. Yeah. I was concerned about that, Your Honour, because when I read it, it didn't say in terms.
But it's two lines, doesn't it? Two-line order. No reason.
It's a two-line order, yes, but it's therefore pretty clear and categoric. What they've done is closed the file. Now, if someone goes and troubles a court to inquire into someone's assets, and the court then takes that file forward, and it then delivers a two-line judgment saying we're closing our files, they're closing their files only for one reason, and that is because the cupboard is bare. So it doesn't say it in terms, but it says it by necessary implication. And that, as Your Honour is aware, dates back to very recently. It's the 7th of August. So, Your Honour, unless I can assist further by general points, perhaps I can turn to the skeleton argument and take Your Honour through the skeleton argument as quickly as I can, because Your Honour has indicated that you've had an opportunity to read things. Yeah. Skeleton argument begins on page 7195 of the bundle. I have it separately, and I have a number of other documents held separately as well. So, but I think I can give you page references to everything. The relevant evidence, as we say, paragraph 3 on page 7196, is Mansour 2 drawing on Mansour 1 in answer to Basiso 4, which was the evidence in support of the ex parte hearing, and Mansour 3, I'm sorry, it says 2, Mansour 3 in answer to Basiso 5.
Yeah.
So Mansour, just to read into the record the page references, Mansour 2 is at section AI, document 2, beginning at page 6399. Mansour 1 is comprised within the exhibit to Mansour 2. So Mansour 1 is to be found at AI document 3, beginning at page 6418. Basiso 4 is, I don't have the section number, but it begins at page 4142. And Mansour 3 is in AI 8 at page, beginning at page 7096. Basiso 5, AI 5, beginning at page 6864. So paragraph 4 of the skeleton argument seeks to summarize Mansour 2, and Mansour 2, just turn that up. Mansour 2, Your Honour, begins at page 6399.
Yeah.
If I can take the court, therefore, to 6399, and pretty soon we'll have to divert to the exhibit. But paragraph 4, she says what she's doing in relation to the affidavit, and in support of her application, she refers back to Mr. Basiso's fourth affidavit and their skeleton argument, the transcript, and the first affidavit of Hala Mansour, which is at exhibit HM2, and that it begins at page 6418, AB3 6418. And it may be just convenient if I take Your Honour, having located the reason for the first affidavit being relevant in her second affidavit. So we have a chronological run at things. If we go to page 6418, and I'll take this as quickly as I can, again in the light of Your Honour's pre-reading. Begins at 6418. She refers to the order of the 27th of May, which is the ex parte order on 6419. And she explains the circumstances of service at paragraph 5. Now, this is relevant to a different point, which is delay. The reason why I pause here particularly is because this paragraph provides details of an email from those acting on behalf of Miss Mansour on the 21st of June, which we say prompted the service of the documents which were relevant and flowed from the hearing back on the 27th of May. In other words, but for this particular pot having been stirred by this particular email, we might not, or my client might not, even have been served with the documents which properly flowed from the... Well, Your Honour has the point. At paragraph 6, foot of the page, she sets out her background circumstances. She's a long-term resident of the UAE. She has a long-term home loan. She has a mortgage department. She has a bank account. She explains her work as company secretary, and she explains that R2 was established in November 2019. So R2 was established when R1 was, the bank account of R1 was closed down because of sanctions. We'll come on to that in due course. facts, she says she's been brought into this without any basis. She again refers to her work as a company secretary in paragraph 13. Paragraph 14, she makes the point of which the court is fully aware. Paragraph 15, again, she develops that point. She explains that she started working for R1 in 2019 and how that developed. And when she was appointed company secretary of D2, paragraph 18, and that she handled all administrative tasks for both companies. No activity for D1. Then here is the sanctions policy relevant to R1. The companies, and indeed D2, the company's accounts were closed in 2019 at the bank's request, owing to the bank's sanction policy. This has no relation to these proceedings, as the claimant claims. So part of what the court has termed intermingling is a needs must change because the bank accounts of Royal View and HMR were closed down by an external third party. D2 owns its own assets, and then the circumstances of the first defendant are explained. Owing to very serious medical conditions, he's suffering from cancer. He was out of the jurisdiction between 2018 and July 2022. And then paragraph 25, she says there are many payable debts, including license renewal fees, bills, and service charges, estimated annually at no less than 3.5 million AED. So this goes back to the point that I've already referred to in general terms, that the rental stream is only looking at one side of the equation. And from that must be deducted all of the expenses. Furthermore, a blockage has been placed on the properties of D2 for non-payment of service charges. So they're doubly frozen, if you like. Then she explains the involvement of Fan Living. Then she says, as you're aware, how R2 managed and supervised the properties of D2. Over the page, paragraph 29, she says the first defendant shares cannot be sold or attached, and that's the key question. The claimant did not notify the defendants of a change of D2's license. Neither I personally nor R2 have any connection or relation to this claim. Then we have a reference to the correspondence, which is developed more fully in the submissions. This is an example of a letter which was written by the Dubai courts to the Chief Justice of the DIFC courts. As your Honour sees at paragraph 34, the claimant attempted to challenge this letter in the Dubai Court of Appeal under appeal number 99 of 2024. Now, at the time when she made this affidavit, the 5th of July, there was not a judgment forthcoming from that appeal, but as is made clear in the skeleton argument, on the 20th of August there was an appeal. There was a judgment in that appeal, and the claimant's appeal was dismissed, was refused. Then she comes to the financial audit reports and disclosure. She's not received personally any sums from D2 from 2019 to date. She's not received any sums from D1 since February 2023, so no breach of the freezing order. She explains again her role as secretary, the long leases being registered with the Land Department, a point I've already made. And then she turns to the audit report, which was attached to this, so a further audit report in relation to 2022. She is volunteering further financial information, Your Honour, which is scarcely the hallmark of someone who's ducking and diving and not being cooperative. She says that the second respondent has only ever provided management and supervision services. She makes that good by reference to the reports that were initially provided by Mr. Basiso and which have been supplemented by her more up-to-date reports. And she explains that as of 2023, there has been no financial report because the portal which D2 would use for the purpose of uploading that report, has been blocked since February 2023, except for license renewal. So the first affidavit is essentially the disclosure affidavit, but she prays it in aid in her second affidavit, which I'll revert to. Your Honour, it began at page 6399 and it continues at page 6400. The first paragraph she deals with, or the first paragraph under introduction, the first couple of paragraphs is in relation to the power of attorney. Let me deal with one point clearly and forthrightly right at the outset. This is the power of attorney under which Miss Mansour was acting. It is said by the claimant, well, there was another power of attorney, and they have provided that. Ms. Mansour has responded and she has acknowledged that that was a power of attorney, but it was never used. She saw her powers as strictly limited within the four corners of the specific power of attorney, and the general power of attorney has been revoked. So
does she say it was never used? She says it's revoked. Sorry?
My understanding was that
that's not her evidence, my lord.
I think the evidence is simply that it's said to be revoked. I don't think she's ever said she didn't use it. But if you can show me the reference to that, that's fine.
That is my understanding on instruction, but if I've misunderstood, and I will check that at a convenient stage, I won't push that aspect at the moment. I'll look at what the evidence says and I will check my instructions. So let me keep within the bounds of the evidence. We'll see what she says in her further evidence in response to Mr. Basiso's further evidence.
Yeah.
But for present purposes, what she is focusing on is the limited power of attorney, the extent of which she explains in paragraphs 6 to 8 of this second witness statement. She makes the point that she's not involved in a party and that she's always taken instructions from the first defendant. We have details of her company secretary acting. On paragraph 14, she says that she has never and has no intention of disposing of any assets belonging to D1 or D2. Neither she nor the second respondent own any assets or even received any sums from the first or second defendants since 2019. And that's why I took you back to the first affidavit. Paragraph 17 at the foot of the page, paragraph 18 at the top of the next page makes the points about the personal effect. Then section B is the delay in service point, which I've already adverted to in general terms. Then in section C, she begins by setting out certain circumstances in relation to R1, which is simply to assist the court. D1 is the shareholder of R1. It was actively engaged in general trading until 2019. You can see now from the earlier paragraph, I think it was paragraph 12, as to, sorry, it was paragraph 12 of her first affidavit. You can see why, sorry, 21 of the first affidavit, you can see why the activities of R1 ceased in 2019. It was because of the closure of the bank account and had nothing to do with this case. And then matters were taken over by R2, her company, which is set out in paragraph 23. Paragraph 24 is now, I think, largely repetitive, save paragraph 24E, where she says, I was not informed of any change in my position as company secretary prior to my witness statement dated the 23rd of April 2024. So that is relevant knowledge, or that date is relevant because she considered herself, she regarded herself, she knew nothing to the contrary, but certainly up until the 23rd of April 2024, she was the company secretary of D2. So as far as she was concerned, she should be acting in D2's interests on the administrative matters which she's described as being within her remit. Paragraph or section D is a deep dive into the accounting reports, and I'm happy to go into the accounting reports in as much detail as the court would wish, but it may be that the court is happy to accept what Ms. Mansour says and the distillation of the financial reports. The key pages are in KAB 6, page 254 and 255 through to 266. Your Honour will find those beginning in AB 3 4409. But what she says is she, first of all, makes the point that these are separate entities. Secondly, that they were subject to external audit, that the consolidated accounts provide a comprehensive view of what the court has termed an intermingling, but with which is a term I don't totally share. It was arm's length professional services. She's made the point about clarity of transactions emerging from the financial data and also the individual accounts. Paragraph 27, KAB page 253 is indeed at AB 3 4409, and rather than turn that up, what I would invite the court to do is look over the page 6405, where she draws a distillation from that page 4409.
I'm sorry, Mr. Patrick Choice, where are you looking at?
I'm looking at her second affidavit, page 6405.
Yes. Yes, got it.
Here she says a close examination of D2's accounting sheet, and for the court's reference, the accounting sheet is to be found at AB document 3, page 4409. But I'm not inviting the court to look that document up, because what Ms. Mansour has done in the table on page 6405 is to distill the important information from 4409, and then at B she's drawn out from the table relevant features which are in the table. So she says this is looking at B, the above, that's the table, sets out that the second defendant's accounts closed had a zero balance. So
what date is this document?
This
is 2020.
Yes, it is, because
I was much more interested in looking at the accounts for 31st December 2022.
Yes.
Which is what I've looked at. Are you coming to that in due course?
Well, I can come to that because that is in those are exhibited to Mansour 1. So let me go back to Mansour 1.
Let's. I mean, what I'm interested in specifically is what appears at page 692. No, sorry, 6935 and 6947.
Let me turn straight away to those, if I may.
This I hope is getting to the nub of the point, albeit that this is only again at 31st December 2022, and therefore not at today's date. But on the face of these accounts, there are some assets within RBM and it's quite clear that there has been collection of income and expenses paid on behalf of related parties out of the bank account, which is held by RBM.
Yes.
And so the question, therefore, is what conclusions has one drawn in relation to assets that are within RBM that may be amenable to execution of a judgment against D1?
Well, no, just looking at page 6935, I think the first conclusion that one draws is that this is reflection of the arm's length transactions of RBM providing the management and supervision services that I've already spoken about. The second point is, and therefore this was in the ordinary course of business, it has absolutely nothing to do with attempted dissipation of any assets belonging to or which may be amenable to execution in relation to a judgment against D1. So this is perfectly standard practice. The second thing is that it demonstrates pretty small measure of profit over each of the 2 years which are set out there. 174,000 dirham in 2021, 187,000 in 2022. I'm sure people more adept at
well, I was just, if you look at cash in hand, you've got 1.8 million dirhams at the end of 2022.
Yes,
not a huge sum in the context of what we're talking about, but not insignificant.
No. Well, the question then is as to whether that is going to make any difference. Well, first, there are 2 points. One is whether it is amenable to execution at all, and we say it isn't for the reasons that we'll come on to in Brodal. But even if it were susceptible of execution, what difference is it going to make? Because the freezing order, and I accept freezing orders are to avoid dissipation and not to provide security, but the value of the properties, and we have Mr. Basiso's evidence of the valuation in the courts, the value of the properties which have been frozen vastly exceeds the value of the judgment debt. Now, I accept that that interest has been added to the judgment debt, but even so, the value of the frozen properties exceeds very substantially the value of the judgment plus interest. So, and the third point is that we've looked at, or can look at, the trading records of RBM. And yes, RBM provided substantial services to D2, but it also provided services to other clients. And the effect of the freezing order, therefore, is to freeze a relatively small business from its entirety of its business activities. And that, we say, is utterly disproportionate, even if all of the other hurdles are surmounted. Now, I can, the other page that Your Honour referred to was 6947.
Yeah, well, that's the one that shows the interrelationship. But what you can't get out of it is exactly how much of the 1.8 million, so to speak, could be attributed to HMR's business.
No, you can't. But it's, I think what one, the picture that one ends up with is as follows. It is a small business with a relatively modest turnover, given the nature of the business, because property management and supervision is an expensive business. The licenses, the management fees, everything that was spoken about by Ms. Mansour in her witness statement, in her affidavit, doesn't come cheap. So you have monies coming in and you have monies going out in the perfectly ordinary course of events. And when all is said and done, and the financial accounts amply bear this out, it's modest. And we are in a position where a modest company, where we say its assets are not in any event amenable to satisfy the judgment, but a modest company and an individual person have had their lives turned upside down by reason of a worldwide freezing order, when the evidence in support of the order was threadbare. It was threadbare because my learned friend only had accounts up to the end of 2020. Doesn't go anywhere near the relevant period. The further material which has been provided for reasons of clarity and transparency takes us up to 2022, and it demonstrates the modest nature. In our submission, it is important to look at that context. Now, the context is made good by those 2 pages, but that submission is fairly and squarely made right at the outset of our submissions. If I may go back to 6405, I'm getting a couple of metaphorical tugs on the gown, so at some stage I will need to just check on what the tugs on the gown are, but let me complete certainly the explanation of her second affidavit, and then I'll come back to any matters which I might need to clarify. So I'm back on page 6405. We can see that there is an accumulated loss, that's in the middle of the page, of just shy of 4 million dirham.
But I'm sorry, Mr. Patrick, I know I keep interrupting, but I'm not quite sure what the historic position in 2020 accounts is going to show to help.
Well, maybe I can short circuit this. What Ms. Mansour has been scrupulous, as Your Honour has seen, in answering every point that Mr. Basiso has made. So what she's doing here is going back to Mr. Basiso's evidence in support of the ex parte order, and saying it doesn't stack up to anything. Now, Your Honour, things have moved on, and Your Honour may rightly say, well, this is historic, where does it lead? If that is the position, I am happy to move on once it is appreciated that my client has taken everything that's been said against her and has sought to provide not only an explanation of what's been said, but additional explanation and material, such as the more up-to-date accounts. And she's also explained why there's nothing for 2023. So she can't go any further. Now, if I look at that, I may not then need to take, Your Honour, to the rest of Miss Mansour's second witness.
Well, the only point you do need to deal with, to the extent you haven't already, is what she says about the power of attorney she actually has, and doesn't refer to the other power of attorney.
No, that
6409, 6409, isn't it?
6409 is where she refers to the
litigation power of attorney. Yeah.
Yes, and if I can just look on to
I mean, however you look at it, not to refer to the other power of attorney is discreditable on the face of it, isn't it?
It's not. It's an oversight, and I accept it's an oversight. Let's look at 7107, 7101, Your Honour.
Mm-hmm.
And here she talks about, she refers back to Mr. Basiso's fifth witness statement or affidavit, and she expressly deals with the scope and content of my power of attorney. So she says that Mr. Basiso's paragraph 11 confirms that the power of attorney granted to me is a legal authorization as stated in my affidavits. I provided the court with the relevant power. Provide the court with a relevant power of attorney pertaining to dealing with the courts and lawyers as referred to in my statements. I do not understand where the alleged obstruction of justice arises. There has been no attempt to mislead the court. The power of attorney that Mr. Basiso references is no longer relevant as it was inadvertently overlooked and now has been revoked and is no longer in effect. So my apologies if I overstepped the point, but it was no longer relevant. It was inadvertently overlooked and it's been revoked, it's no longer in effect. She wishes to clarify to the court that in both her first and second affidavits, she was referring to the legal power of attorney that she had been relying on when presenting herself to the court and which she had been using in her dealings with the courts since 2016, as she has mentioned. So, Your Honour says it's discreditable. I would urge the court not to regard it as at all discreditable. It was an oversight because she has now made clear that she was working consistently in relation to under a power of attorney which had been in place since 2016. The subsequent power of attorney was, I think, we have a date. It was
if it assists my learned friend, it's the second.
It was dated the 22nd of May 2023, which is made clear in paragraph 12 of Mr. Basiso's witness statement, page 6866. So she has a specific power of attorney which has been there for the entirety of the legal proceedings. Of course, the legal proceedings go back and include the Dubai court legal proceedings, as well as the DIFC court legal proceedings. Though that was the basis on which she was acting. Yes, there was another power of attorney, but it was of relatively recent origin. It was therefore not in her mind as being relevant to the court process. And she relied on the relevant power of attorney. And when it's pointed out to her, she makes it absolutely clear that she inadvertently overlooked it because she was relying on the power of attorney under which she had been acting throughout, and that was a limited power of attorney. So, Your Honour, of course, if she'd recalled that there was another power which was unused or irrelevant, then in the spirit of absolute full and frank disclosure, of course, I'm sure she wishes that she'd thought about it and recalled it first time round. But it really isn't discreditable for an oversight to occur of this nature in these circumstances. Your Honour, asked me about the power of attorney, particularly in relation to Miss Mansour's second affidavit. What she does is, again, as Your Honour has seen and read.
Well, I think you've covered the ground as best you can on that, Mr.
Well, I'm obliged, and there is there is a lot of material in her affidavit, but as I say, she takes Mr. Basiso's fourth witness statement, answers that. She takes the relevant paragraphs in the claimant's skeleton argument in support of the ex parte order and answers that. Then, in relation to her further evidence, she responds, as I say, to Mr. Basiso's fifth affidavit. We've touched on this a little bit, but her response to that, dated the 30th of August, is begins at page 7096.
Yeah.
And there is a lot of reinforcement of what she said previously, both in relation to personal harm and her own status. But then beginning at page 7100, paragraph 18 or section B, headed response to KAB5, Mr. Basiso's fifth affidavit, she goes through 1819 all the way through to the very end, 7115, 7115, answering very specifically what is said. So, Your Honour, I wonder, before I revert back to my skeleton argument, if I can just check on the metaphorical tugs on the gowns, the gown, to see. I am asked for 5 minutes. I wonder if it would be convenient just for me to take 2 minutes to check on matters that I've made submissions on already before I launch into the detail of the skeleton argument. Would that be convenient, Your Honour?
Yeah, well, I don't mind taking a break. Just tell me where you're going next.
Well, I'm going to.
What you plan to deal with?
Because half my legal team is in Dubai and I'm in London, I need to make sure that I'm on the right page as far as what I've said so far. And then I would intend, with the benefit of what I've already said, to turn to the skeleton argument and take that as quickly as possible.
Yes, and do you anticipate being broadly how long?
Brodal, the law is quite important and quite detailed. Your Honour will have a detailed knowledge of cases like Globe Investment and Broad Idea, but nonetheless, it's helpful just to refresh one's mind about the relevant paragraphs there, but also Brodal, which is relatively new and is a judgment of David Foxton, which is in our submission highly material, and therefore one needs to go through the facts and the implications.
You haven't answered my question.
I haven't answered your question. It was prefatory to an answer to your question. I would hope I could do it in. I've been going for an hour and a half. Another hour and a half.
Well, I encourage you to see if you can do it shorter than that.
I'll see what I will take instructions and hopefully a stitch in 9.
My lord, if I'm not interrupting Mr. Patrick Joyce, just one point before we do break, if we are about to, I suspect it may be one of the metaphorical tugs on Mr. Patrick Joyce's gown is that the Chief Justice has this morning handed down his decision dismissing Mr. Rashed's application for permission to appeal. Would it assist your lordship if that was provided to you at some point during the course of today's hearing? I don't know whether the registry can do it or whether we can do it. Probably
not. I mean, I can't think that it's going to impact on
no, well,
what I have to decide today at all, unless I'm in the 10-minute break that we're about to have. You can have a quick flip through it, no doubt, and see whether there's anything which does impact on the argument today.
Yes.
It didn't seem to me that it was likely one way or the other, whatever he decided to impact on today, but I may be wrong about that because I haven't thought through the implications fully. We'll take 10 minutes now, and that
9:37.
Well, we'll say 9:40, shall we, to be sensible.
All right.
Thank you. Yes. When you're ready, Mr. Patrick Joyce.
Your Honour, I'm obliged. There is only one matter that I need to take Your Honour back to, and that is in relation to the expenditure on the service charges and ancillary matters,
Yes.
and the running account. Could I invite the court to look beginning at page 6478? And if Your Honour has it, Your Honour will see that this is entitled Dubai Community Management Service Charge Statement for the period of the 1st of January 2006 to the 25th of September 2023. Now, it's a very long document. It runs to 381 pages. I'm not going to take Your Honour to anything other than the last page, having identified what it's in relation to. And you can see from the left-hand side and the boxes immediately under the title that it relates to the City Walk community residence, and the customer name is identified as the second defendant. So this is a running record of all of the service charge statement. If Your Honour goes to the final page of this document, which is at 6857, Your Honour can see at the...
Hold on.
Oh, sorry.
68. Yeah, sorry, we're there now. Yeah.
And this takes it through to September 2023. This is all produced by Ms. Mansour. And Your Honour can see, bottom right-hand corner, that the grand total is 913.55 dirham. So this is the running total of the accounting for the service charge for the entirety of the period. Again, full transparency, complete neutrality as to the accounting consequences, and it demonstrates in our submission that what was coming in was matched by what was going out, and that takes no account of historic debts, which Your Honour has seen in Ms. Mansour's second affidavit, where she spoke about the loss of nearly 4 million dirham, which
I'm
was
not quite following.
Accumulated loss.
I'm not following the significance of this.
Well, the significance.
This is simply. This is not the overall income and expenditure account on the properties. This is simply service charge, is it?
It is simply service charge. It demonstrates. What it demonstrates is the outgoings.
Yeah, no, I understand.
Yeah, that was the only point that I needed to take on to. Let me revert now to my skeleton argument, and
yes.
That is, let's pick it up at 7196. Paragraph 5 derives matters from Ms. Mansour's second affidavit. Your Honour is aware of that. Paragraph 6 raises the key point, which Your Honour has raised as well, that the claimant has produced no evidence to show how any of the assets of R3 or R2 might be susceptible or amenable to execution to satisfy the judgment debt. That point was made by Ms. Mansour, particularly in her third witness statement. We provided that. And then going over the page, the further specific points, I think have all been already dealt with. The first point provides page references to the Dubai court's recent investigation back to the 7th of August, simply page references for Your Honour's note. Point 2 is the audit reports. We've looked at that. Point 3, something that I've already raised, and Your Honour has again the cross references in the evidence, that the vesting, the gift from of the City Walk properties, so vesting in D2 cannot be reversed, and that's been recognised by a decision of the JJC. Again, information provided. Let's turn now to the law. And Your Honour, I'll take this as quickly as possible because Your Honour will be, I think, probably very or fully familiar with cases like Globe Investment, which is to be found at AL 17.
Well, if you're simply going to take me to cases on freezing orders, I don't think that's likely to be necessary. I'm much more interested in the later points you wanted to develop.
Yes, the only point, I wasn't planning to take you to Lakatamia and Moritomo or Thane Investment, but and it may be that it's actually better dealt with in the broad idea case.
Right.
The broad idea, if Your Honour looks at, I'm afraid it has to track back in the bundle to page 4483.
Yes.
I'm obliged. That should be the first page of broad idea. If Your Honour goes on to the foot of page 4508, it should be paragraph 88.
Yeah.
I'm sorry, I'm just getting there myself. Yes, paragraph 88. It's the enforcement principle, which is relevant to a couple of extracts from which we'll see in Brodal. It's often cited. The enforcement principle also explains the basis and scope of the jurisdiction to grant a freezing order against a third party, against whom no claim for substantive relief lies, a non-cause of action defendant, NCAD. The ordinary prerequisite for granting such an injunction before taking account of discretionary factors is that the third party is in possession or control of an asset against which a judgment could be executed. That test may be satisfied because there's good reason to suppose that the asset is beneficially owned by a defendant against whom the claimant has obtained or has a right to obtain a judgment, as in the Shabra case. May also be satisfied in other ways, etc. So really that is there because it underpins the doubly bad point that I've already taken.
Well, it's the bit that goes on, isn't it? It may be satisfied in other ways, right of indemnity, transaction by which defendant transferred an asset to third party might be avoided under section 423 and so on, whereupon or enforcement of a judgment might lead to liquidation and so on. So they envisage any number of different processes, which is where the question of tracing comes in, and the potential for setting aside transactions on a insolvency basis, which none of which has happened here yet, but is, I suppose, potential.
Well, Your Honour, certainly none of which has happened, but is it potential? Because things like this have already been investigated. The reversibility in front of the Dubai courts has been investigated by the claimant, and it's drawn a blank. So that is relevant to the full test. If a door is open and available under the English provisions of section 423 and 425 of the Insolvency Act.
Well, doesn't that raise all the difficult conflict questions that we've already touched on? I'm supposing the second defendant is put into liquidation. Then, what doors are then open is the question.
Well,
but it's put in, it's a real, again, it's a minefield. But if you've got a company that's registered in the DIFC and it's put into liquidation in the DIFC, DIFC insolvency regime applies, and then you've got to work out how that impacts on assets that are elsewhere, and particularly, of course, in onshore Dubai.
Yes,
and
absolutely.
None of these things have been, as far as I know, very thoroughly worked out.
No, but I agree with everything that Your Honour has said, and would simply add that the indications, a strong indication is that it wouldn't be, the assets would not be available for distribution because the insolvency regime would be under one jurisdiction and the assets would be locked in another jurisdiction.
Well, it would be a question of, I don't know how familiar you are with the insolvency, but usually you have a main proceeding and then subsidiary proceedings in other jurisdictions. A bit depends on what conventions people are party to and so on and so forth. And it is particularly acute difficulty, I think, here between the DIFC and onshore Dubai, because the relationship is complex.
Well, Your is correct.
And
that,
I can't. My difficulty is I can't anticipate any of that.
Well, yes, and Your is right that I'm not going to be a fool and rush in on an area which is not really my prime patch of insolvency, but certainly Dubai onshore insolvency is definitely not my patch, and builds on what Your Honour has just said, that there are acute difficulties even within that particular pocket of this or the particular part of this particular pitch.
Right. Yes, go on.
Yes, I was. Yes, we were looking at broad idea and the enforcement principle, which is easier to identify than to apply in the particular instances of this case. If I go back to the skeleton argument, paragraph 9, we simply say there are no assets that are amenable to execution, certainly not so far as R3 is concerned, and R2's assets are simply assets in the ordinary course of business. So therefore, how is it established that those assets are at all amenable to enforcement in relation to a judgment against D1 if the assets are part and parcel of the ordinary business carried on by R2? It's, if you like, an indivisible whole. Yes, there is a small amount of profit and some cash in hand, but where does that, is that amenable to execution when the traceability, the control test, none of the requirements for amenability are satisfied? And these are, by way of bullet points, I will pick them up in slightly more detail in the rest of the skeleton argument. Paragraph 10, another point, going a separate point, we say that the claimant failed to provide adequate information in two respects. In the first respect, it was an obligation, we say, on the claimant to explain to the court at the ex parte hearing that there had been decisions by the Dubai courts, and on the back of those decisions, correspondence had been addressed by the Dubai courts to the DIFC courts, making clear the execution protocol, the execution procedure that the Dubai courts was setting out. None of that was explained, and it should have been, because that goes to the non-executability against the shares in question, and no relief and no ancillary relief can be obtained against R3 and R2, which is wider than the relief which is properly obtainable against D1. Now, D1 cannot say anything about that because of the debarring order, but on the basis that an ancillary order can go no wider than the order to which it is ancillary, if the order to which it is ancillary can bite on nothing in the jurisdiction, then in our submission it must follow that the ancillary order can bite on nothing in the jurisdiction. There's also another aspect of when the court was materially misled. The court's aware of that point. Then paragraph 11, the personal effect on Ms. Mansour is set out. Paragraph 12 brings us to Brodal, and Brodal is to be found in bundle A11, AL number 19, beginning at page 9358.
My bundle doesn't go up to 9358.
Oh, my apology. Well,
hold on. This is what I was sent. Let me go to the case lines thing.
Ah, yes. The case lines is the reference I've given.
Yeah, hold on then. Bear with me while I have to work out how to do this whilst not
it's
turning
not
off. Well, not turning you off at the same time. To do.
My lord, would it be easier if one of the parties sent you the most recent PDF version?
Well, yes, I was working from a PDF version that had been sent to me by the courts probably a day or two ago before the authorities were added, I suspect.
Yes, but they work with the case. Yes.
Yeah, my instructing solicitors have said they can send that to you in PDF form if that helps, my lord, immediately.
That probably be the quickest way of doing it. Otherwise, I've got to go in and out to get both the case lines thing up at the same time as the hearing document, which is not impossible, but just takes me a little while to work out. Anyway, go on. Tell me what you're going to say about the authority, and then we'll look at it in detail.
Yes, Brodal is a case where Mr. Brodal was a judgment debtor, and he was 100% shareholder of various companies through which he provided consultancy fees, and the fees were then paid out by way of dividend. And it's unclear as to the precise circumstances, but it may be that Mr. Brodal had put that all in place in an attempt to judgment-proof himself. And the question then was as to whether what was sought was a declaration that Mr. Brodal had control over the revenue streams of consultancy fees and dividends through the companies. So the question then was whether, as a 100% shareholder, he was acting as in any sort of sense of personal capacity, or whether he was acting on behalf of the company, and that therefore respecting corporate personality, you couldn't, the traceability issue ran into a brick wall. And that was obviously interwoven with freezing order jurisdiction, where in fact on the facts of Brodal, there wasn't an order, there had been an undertaking given.
I'm not quite following this for the moment.
Well, would it be, I'm trying to talk in general terms without going to the particular paragraph.
Yeah, no, I understand, but they weren't trying to enforce against his shares in the companies. They were trying to enforce against the companies because he had companies' accounts, because he had control of them, because he could, if he wanted to, have paid himself dividends. That was the argument, was it?
Yes, yes. So it's relevant to other assets, and particularly here, the assets of R2 and R3.
Yeah, well, I've got all that point. It really comes down to the intermingling point again, doesn't it?
Well, here, of course, there was, if you like, a sort of unity of interest between the shareholder and the company, whereas what we have here as between R2 and R3 is not a unity of interest, because the company D2 is D1. So it's more remote. And given that the declarations were not granted in Brodal, the fact that in a closer relationship where declarations were sought and not granted, and yet in a more remote and extended relationship, here a freezing order was sought and was granted. And we say that that was fundamentally wrong because of the tension that Mr. Justice Foxton identifies in the development of the freezing order jurisdiction. So he goes back to the origins, rather like Broad Idea and Lord Legate, and charts the development, and then detects and identifies a tension between the enforcement principle on the one hand and the corporate personality principle on the other. And what we say is that that tension arises again here, and that what happened at first instance in the ex parte hearing was that the enforcement principle was preferred by the court over and above the corporate identity aspect, and that therefore the tension that is identified by Mr. Justice Foxton simply wasn't really grappled with by the court. And we say that this should have been brought to the court's attention because it provides an obvious argument that R3 and R2 would be advancing in any event, and therefore in the context of full and frank disclosure, it should have been brought to the court's attention. That's the first step. Having brought it to the court's attention, we say that there is a clear irreconcilability between the outcome in Brodal, where the declarations sought were not granted, and the outcome here, where at the ex parte hearing, the court not having been alive to this line of argument, the court found that an injunction should be granted. Does Your Honour have the PDF?
No, but I've got it now on case line, so it take me to any passage in the judgment that you want.
Well, let me just recap. Paragraph 1, Brodal was a judgment debtor to the second claimant.
Yeah, no, I've got the structure. It's the
structure.
It's the principles that I'm interested in, as expressed by the learned judge.
Yes, then I think we can go to I think probably starting at the very foot of page 9363 is the heading, the assets to which the freezing order extends.
Yes.
And what Mr. Justice Foxton does here is at the head of the next page, he talks about the development of the jurisprudence for freezing orders, which I've referred to. He then summarizes that development, the evolution in the wording, paragraph 23 and the subparagraphs there. Paragraph 24, the principle underlying the freezing order injunction intends to prevent the unjustified dissipation, and he sets out matters there. Then at paragraph 24.3, he sets out what he considers to be the purest formulation of the enforcement principle. It's quite long, but I would invite Your Honour just to read the two paragraphs extracted from Sir John Chadwick's judgment in Al Ghasabi, set out and indented at the foot of page 9365 and reading over to 9366.
Yeah, well, I mean, that's all thoroughly orthodox, it seems to be, as one would expect from David Foxton. He's a very smart man.
David Foxton and indeed Sir John.
Indeed, yes.
So
Yes.
David, yes, but in particular, the last, say, 10 lines, so from 3 lines down on page 9366, it's not enough just for there to be substantial control. And we say, where is the substantial control exercised by D1 over R3 and R2? It just doesn't exist. So you don't even get onto that starting point. But that, even were there substantial control, it's not sufficient because there has to be some other factor. But then, paragraph 25, this is the tension that I spoke about, Your Honour. The tension is at its most acute where the respondent controls a company which owns assets and an attempt is made to apply the freezing order to those assets rather than just the shares of the company. And this again highlights and underlines the fact that what's happened in relation to R3 and R2 is at one step removed even from this acute tension identified by Sir David. So it's, if you like, an unexpected, even more acute tension, which derives from or follows from the tension identified by Mr. Justice Foxton. So just picking up, because of the risk, just completing the paragraph, that it will fundamentally undermine the distinct nature of corporate personality under English law. And then he goes through, again, very carefully and methodically, the building blocks necessary to investigate this tension. First of all, talking about the Group 7 case, then about the Lakatamia case at the Court of Appeal. Then little Roman 4 on page 9367 is actually quite important, because it has been some suggestion that Mr. Justice Foxton's judgment is inconsistent with Abdolshahid number 10, but it can't be said to be inconsistent with Abdolshahid number 10 because Mr. Justice Foxton takes express account of Abdolshahid number 10 in the Supreme Court at little Roman 4. And then he goes on building up the argument. Your Honour will see it, little Roman 6, a reference to convoy, collateral and broad idea. And then paragraph 26, he does say that there may be a number of reasons why it might be appropriate to cast a wider net. Well, we've taken that comment and analysed it by reference to the present facts. And in our submission, there's no basis for this casting of a wider net. And that goes back to the question that we've already been discussing about the views of the Dubai courts in relation to assets which are located in onshore Dubai. That's then explored in different context in the Roman 1 to Roman 5. And then paragraph 27, on behalf of Mr. Broad, on the preliminary objection that the court should not entertain an application to give a declaration as to the application of the England-Wales freezing order relies on the principles set out in the decision of Mrs. Justice Dias in Invest Bank and El Husseini. Now, just pausing there, of course, this is another spin of the kaleidoscope in terms of changing patterns, because, of course, Mrs. Justice Dias's judgment in Invest Bank against El Husseini went up to the Court of Appeal, and the Court of Appeal came to a different conclusion, which has itself now gone on to the Supreme Court, which was argued over 2 days in May, and where the judgment is still awaited. So even on this bit of the building block, there is a question mark. But that notwithstanding, paragraph 29, Mr. Justice Foxton reaches the following conclusion. He doesn't feel able to make a final factual determination at this stage, not least because Mr. Brodar probably wasn't expecting what happened in a 2-hour hearing, but he then goes on to identify the top of page 9370. Your Honour will recall that when Your Honour talked about grounds for belief, I said the enhanced standard of arguability. This is the source of my reference to the enhanced standard of arguability being applicable. And then he goes on to identify what the right test is. Don't think I need trouble the court with paragraphs 31 to 33, because here we're dealing with a worldwide freezing order, and that's dealing with a domestic freezing order. But paragraphs 34 and 35, really the nub of it. As I've already noted, I would not be willing to make a final determination of this issue at the hearing for the reason I've set out above. However, on the material before the court, the claimants have not established good reason to suppose that this is the case. Roman 1, so far as the consultancy fees are concerned, the arrangements whereby Mr. Brodell's services were provided pursuant to a consultancy agreement with a company appear to have been in place from shortly after Mr. Brodell became a director of Waldorf. There were similar arrangements for other staff, and the existence of the arrangements was disclosed in audited accounts. The arrangement is a well-known one. Whatever benefits would be set at naught if the employee was the beneficial owner of the income stream, and the disclosure given in the audited accounts would be unnecessary and inaccurate. There are no features of this case which would explain why Mr. Brodell should have procured the conclusion of a consultancy agreement with a company Waldorf, should have paid Ultima under an agreement and disclosed the arrangements in its accounts, when, i.e. if, the true position was that Mr. Brodell was the beneficiary of the debt. Well, by parity of reasoning, but at one removed, there can be no basis, we say, for it being alleged or asserted that Mr. Rashed was the beneficiary of any asset in R2. And then, so far as the dividends are concerned, there is a complex but conventional corporate structure which is recorded. The material which had been relied on to establish a beneficial ownership is or are the ordinary consequences of 100% ownership of those entities at the time of the transaction. If these were sufficient to establish good reason to suppose that the rights in question were not the company's but Mr. Brodell's, this would be the case in almost all one-person company cases. But this is a massive extension. Sorry, I just need to plug my computer in. This is a massive extension. This present case is a massive extension, even beyond the questions raised by Mr. Justice Foxton, and which he resolved in favour of Mr. Brodell. Then did he control the right to the dividends and consultancy fees for the purpose of the freezing order? Once again, I am not willing to make a final determination, but on the material before the court, the claimants have not established good reason to suppose that this is the case. There's a little bit of a wrinkle between two companies. Pardon me. Ultima and Eden Roses. He said it's sufficient to consider the position of Ultima. On the basis of the decisions in Group 7 and Lacatamia, to which I've referred above, the definition of assets in the freezing order does not extend the order to assets of companies wholly owned or controlled by Mr. Brodel. And actually, when you look back at the freezing order here, we can see that. I think it's page 1246.
But the essential point here, though, if it were shown to be the case, is that the assets owned by D2 are really owned by D1, because there was a transfer made in 2019, which was, quote, with a view to making himself judgment-proof, defrauding creditors, or whatever you might think. And so if D2's assets are really those of D1, they are subject to a judgment against him. And if D2's assets become intermingled with the assets of RBM, for example, then there may be traceable assets that actually belong to D1. I mean, that's the basic argument, and none of this touches that as such, because they're concerned here simply with the issues of personality, corporate personality, and how that impacts on and control. None of that is relevant for current purposes. Now, and that seems to me, on the face of it, to be the real question. And what I'm putting the point, frankly, what troubles me is that there isn't much there at the end of the day when you're looking either at R2, R3, or R2.
Yeah.
R3 is in a slightly different position anyway, but R2 has, as it would appear, an income stream in its bank accounts that comes from D2's properties, which are said to be really D1's properties. That's the point, isn't it?
Well, Your Honour, let's take it in stages. The properties themselves, accepting for present purposes, but only for present purposes, the traceability point in relation to the properties themselves. They've been transferred. They properly belong to D1. They go back to D1, and there can be execution against them in support of the judgment debt. But the properties themselves are one thing. The dealing with the properties for reasons of property management and supervision, something completely different, because that is.
I've got all of. Forgive me, Mr. Patrick Joyce. I've got all of that point. An arm's length contract and so on is one thing. If you have getting paid service, getting paid management charges, but when you've got an intermingling in the accounts themselves of what represents an income stream, those sums can be traced to the properties which are said to belong to D1. Now, if the reality is there's nothing there, because actually nothing has come in, then that's a good point in practice. The theory still holds good, doesn't it?
Well, let me take the revenue stream. This goes back to a submission I made differentiating between revenue stream or rental stream, rental profits, and dividends. And okay, let's assume that there is a rental stream, but that's only looking at one side of the equation. What we've done by looking at the audited accounts is to show what's going out. And in fact, what was going out rendered the stream nil. And indeed, because of accumulated losses, there was a loss, a debt owing the other way. So a debt owing from D2 to R2, and not R2 holding D2's assets. so that when you look at it, when you look at the accounts, that was why Ms. Mansour spent a lot of time in her affidavit evidence going through the accounts. There is nothing in the kitty. And if there's nothing in the kitty, there is absolutely, there are no assets. So there are no assets to fix upon. There are no dividends which can be payable because there's no profit. And that is regardless of the fact that R2 was also acting on behalf of other companies. And the freezing order means that R2's entire business is paralyzed, which is wholly disproportionate, given that on investigation, as I say, the cupboard is bare so far as the claimant is concerned, even if all of the assumptions about traceability are resolved at this stage in favor of the claimant. So the claimant has to win on absolutely everything in terms of traceability. And even when it does win on traceability, there isn't anything there which goes to satisfy a judgment. All the while, the second respondent's business has been paralyzed, and the third respondent has been literally frozen and is in a state of complete status. Her company is frozen, her bank accounts are frozen, and she can do nothing until the freezing order is lifted. So there's, if one tests it on interest of justice, if one tests it on just and convenience, those matters plainly weigh overwhelmingly in favor of the discharge of these orders. They serve no purpose for the claimant. Now,
can you just show me in the most recent accounts where it is that it is said that D2 owes R2 money?
I don't think I can show it to you in the most recent accounts.
Right.
But what? I'm
so
sure
where do I find it then?
You find it in it's AB3 4409.
4409. Okay.
And yes, if you look at the AB 33409, just above you have bold headings, bank accounts, then bank balances, then due from a related party, then payables. Just above the payables, 2 lines above payable, about the middle of the page, this table, accumulated loss.
Yeah, I'm afraid my case lines is going round in circles while it locates 4409.
Oh, my apologies.
Yeah, well, that's why I don't like using it.
No, if it's of any help, it's in bundle AB, document 3. If your Honour has a drop-down menu on the left-hand side.
Oh, I see. Say that again.
AB, document 3.
Oh, right. Okay.
It should say sections. A to Z.
Yeah, got it. Yeah, no, got it.
AB 3, and then it's 4409.
I'm sorry to interrupt, Your Honor. I have now sent you the case bundle as a PDF on your email.
Okay, well, let's see if that's arrived. No, they won't let me do it. Won't let me open it. That doesn't work.
I will send you another version as well.
Well, the reason it doesn't work, I think, is probably because it needs verification through my DIFC email address rather than my my personal address, which I use.
I will now try to send you a version that doesn't require verification for your alternative email. Thank you.
Life was much easier when we worked with hard copies.
That's why I print quite a lot of it off and have it marked up. It's the only way I can navigate around.
Can you tell me what the document is that I meant to be looking at?
Yes, it's an exhibit. It's page
Yes, but what is it?
203. Well, it's a document that Mr. Narciso obtained from the auditors of D2, and it shows the picture as of 2019 and 2020. And of course,
That's
the
what I've got.
importance.
It's come up now. Yes.
Excellent.
It,
Now,
so what?
This
What is it? It's an audited.
It's an audited spreadsheet in relation to HMR D2's affairs.
But so this is back in 2020.
It's 2019 and 2020, reading across from right to left.
Okay.
Now, Your Honour asked about up to.
Oh yes, I got it. Yeah. Yeah.
Your Honour asked about the up-to-date position. Of course, HMR.
Yeah. Well, I'm sorry. Before we do that, can you just identify where I should be looking there?
Yes.
It's the very bottom line, is it?
No, the accumulated loss is an entry about almost in the middle of the page or in the middle of the table. There's a bold heading payables, two entries above, you get to accumulated loss. So you have an accumulated loss by HMR of just shy of 4 million AED. Now, Your Honour says, where does Your Honour find that updated? This is the updated version because Your Honour will recall the evidence of Ms. Mansour at paragraph 21 of her first affidavit, which was that the companies, i.e. R1 and D2, the company's accounts were closed in 2019 at the bank's request, owing to the bank sanction policy. And thereafter, there was no activity so far as there was no banking activity so far as D2 is concerned. So the accumulated loss as in 2020 simply sat there. So that is monies owing by D2 to R2.
Why is that money owing to R2?
Well, that is again in the evidence of Ms. Mansour, because she says that there was very nearly 4 million dirham owing from HMR to D2 to R2, and
Give me the reference to that.
I'm searching for the reference. I may have to supplement that. I had it to hand when I was going through the witness statements, and I don't have it immediately to hand.
Okay.
Again, I'll provide that at the short adjournment.
Okay.
But that's almost sort of the cherry on the icing of the cake, because what I was saying was basically that R2 owes monies, D2 owes monies to R2. But really, for present purposes, all Your Honour needs to be satisfied of is that there is no traceability so far as R2 is concerned. Sorry, I'm just, there may be a clarification. I think, yes, I may have got my R's confused. I think it was R1 was at that stage paying the expenses to R2. But so let me not confuse the picture by looking at monies owed by D2 to either R1 or R2. The question really is, when you look at the rental stream and you look at the rental profits, there is nothing on which a judgment debtor can seize, or there's nothing on which the there's nothing to bite on in relation, there's nothing which is amenable or susceptible to discharging or defraying the judgment debt. I'm sorry, I may have. Can I come back to that point, because I'm aware that I've not made it as clearly as I would have wished to. The essential point is the point of departure of paragraphs 34 and 35 of Brodal. Your Honour was saying that paragraphs 34 and 35 of Brodal don't really meet the point, but in my submission they do. because they demonstrate that what was within the 100% company was not established as being under the beneficial ownership of the 100% shareholder. And here, one would have to establish all of the steps of traceability, over which there are substantial question marks. And even when one establishes traceability, what is residing in R2 is a small net profit and some cash at hand. But that is its assets, not even R3's assets, and certainly not attributable to D1 in a way which makes whatever is within R2 susceptible or amenable to execution in discharge of the judgment debt, or in partial discharge of the judgment debt. I think that's a better way of putting it, Your Honour.
Okay.
So that's Brodel, and we rely on Brodel substantially because for the reasons that have been articulated. If I can go back to the skeleton argument, page 7198, we looked at the way in which the case was put at first instance in the ex parte hearing. We've looked at the transcript where the Shabra jurisdiction was explained. I won't weary the court with taking the court to 6 pages. You have the reference. But what essentially the court was told, it was taken to G on commercial injunctions, 2 paragraphs. It was taken to a first instance judgment, Natura Studios, and it was taken to Lacatamia and Sue. We say that the explanation of the law there was rushed and superficial. The court, the skeleton argument does refer to a broad idea, but only in the context of a footnote, and broad idea explains the enforcement principle, and that in itself has been further developed by Brodel, which explains the tension between the enforcement principle and the corporate personality principle, if I can classify the other principle in that way. But having done that, C's case is put as follows at the end of the towards the end of the extract that I've invited the court to refer to. So looking at pages 49 to 55 of the transcript as a whole, at page 53, C's case is as follows. We are looking at assets being held on behalf of D1, which in my submission we have here, or potential other ways of realizing those assets, like reversing transactions, etc., which we will also have. And Your Honour will recall that Your Honour said, but none of that's been done, has it? To which the answer is no. And we now know that attempts were, or investigations were made, and attempts were made in the Dubai jurisdiction. It comes to nothing. So paragraph 16 I've already read, and we say it's incumbent upon the claimant to go much, much further, and that essentially it's a totally inadequate basis for obtaining a worldwide freezing order. Then we take a point in relation to the jurisdiction being exceptional. And if I can ask you to look at Lacatamia, which is to be found in AB 10, beginning at page 4577.
Well, I don't see this point at all, really, Mr. Patrick Schweitzer. The the transcript shows that I was told in terms that this was an exceptional course. You know, that I don't see anything in non-disclosure in relation to this, particularly in an area of the law that I'm not wholly unfamiliar with.
Well, I certainly accept that Your Honour is very familiar with this area of law, and that is absolutely correct. But let me not press that point because there are other better points. Let me go on to paragraph 18. This is the point I've already made, that the relief against ancillary relief can go no wider than the substantive relief, and if the substantive relief isn't grantable, then nor should any ancillary relief. Then paragraph 19, you have the values, the value of the frozen property against the value of the judgment debt. Then paragraphs 20 and 21, we try to investigate what is the claimant's real...
Before you go there, we do know, do we, on the evidence that there's no mortgage loan charge or anything on the properties?
I am sure that that would be disclosed on the records of the Dubai Land Department, and certainly had that been the case, it's a point that the claimants certainly would have made. So I cannot give evidence, I cannot point to evidence establishing a negative, but what I can say in answer to Your Honour's point is that looking at the available evidence and the fact that everything is recorded on the Dubai Lands Department records, if that were the case, I would have thought that it would have been very clear, and if very clear, very clearly brought to the court's attention.
I have a recollection that somewhere it is said that they're unencumbered, but I can't lay my hands on it. Anyway, perhaps you could make a note of that so that it can be confirmed to me later, perhaps.
Yeah, Your Honour, I'll if we can find the reference, we will. But that is, as I understand it, to the case. Yeah. Paragraphs 20 and 21, good arguable case. What we're trying to look at here is, well, what is the real concern of the claimant? Is the concern that we will somehow dissipate the properties or interfere with the properties, or is the concern that we'll interfere with the revenue stream?
Well, it's the latter, isn't it?
It has to be the latter, and that's back to a point I've already made. Real risk of dissipation.
Yes.
We make two. Well, the claimant's case is based on two arguments. Again, going back to the transcript and skeleton argument. First, they say, well, risk of dissipation has already been found. That won't do with respect, because that is risk of dissipation found as far as D1 is concerned and D2, because they were the parties that were subject to the freezing order originally. You cannot simply borrow a risk of dissipation by, found against one party and apply it wholesale against wholly different parties. And they say the risk has been heightened by the fact that D1 has acted in clear and flagrant breach of the WFO. What we're looking at is the behaviour of R3 and R2, and they've behaved in a very different way from D1. The law on dissipation, again, Your Honour, probably doesn't need to be taken to any of the cases. And what we've done is set out the summary that His Honour Judge Pelling KC set out in 4 VVV. And going over the page, the particularly important point here is really 3 and 4. Again, second nature to Your Honour. The risk of dissipation must be established separately against each respondent, which goes back to you can't just import risk from one party to another. And little Roman 4, what must be established is unjustified dissipation. We've looked at the evidence which was put forward in support of dissipation in front of the ex parte hearing. It's Basiso 4 sections E and F, and there is simply no evidence of risk of dissipation. Nor we go on at paragraph 25, was there any separate treatment of each respondent? And that plainly is essential, because it's vital to differentiate between the parties, because R1 is D1's company, R2 is R3's company. Whatever might be the risk as far as R1 is concerned, the same risk cannot be ascribed to R2. And R2 being the company through which R3 carries on business, receives her salary, that receipt of salary is not an unjustified dissipation. And we say that the claimant must point to what is at risk of dissipation and why such dissipation would be unjustified. And we say quite simply, if you look back at the evidence before you at the ex parte hearing, Your Honour, neither of those points were covered. And we say that that failure is a fundamental flaw in the claimant's argument as advanced in the ex parte hearing. As for R3, and this is going back to, again, the skeleton argument and the transcript. As for R3, the basis is said simply to be the same, mutatis mutandis. So where does that really take the claimant in putting their case? They have advanced no evidence of dissipation so far as R3 is concerned. They have given no separate treatment to R3, simply saying mutatis mutandis. They have identified no identification of what is said to be at risk, nor why any dealing with anything was unjustified. And again, no risk, no revenue stream, no interest of justice, no just and convenient. Just and convenient is at the foot of the page, and that's a point I've already made. Factual disclosure and accuracy. The paragraph 31 is a point that Your Honour, I know, has firmly in mind. I don't need to weary the court with paragraph 31. Paragraph 32, nor can it be said that R2 is captive to D1 and 2. This goes to the in the pocket point. It was not in the pocket of D1 and D2. It had other properties which it managed and which it supervised. And then we make the point at section 4B about the non-disclosure and the failure to set out the context. Now, this is long, but I think can be dealt with quite shortly. We say in paragraph 34, there are two crucial strands which we identify as the Dubai court decisions and the Dubai court execution correspondence. They are itemized with a further judgment of the Dubai court also being relevant, identified in paragraph 38 with all cross-references set out in the tables. When we then look at the skeleton argument and the transcript of the ex parte hearing, none of the contents of paragraphs 37 and 39 were drawn to the court's attention. I accept that the content of paragraph 38 couldn't be drawn to the court's attention because it happened after the event, but none of this was drawn to the court's attention. And in our submission, the court really should properly have been informed that the Dubai courts had said time and time and time again, this is paragraph 43 of the skeleton argument, page 7207, that the shares that D1 held in D2 are non-executable. And if that's the case for the primary freezing order, then it applies just as strongly to the ancillary circumstances which are relevant to R3 and R2. If there is nothing that can be executed upon in the DIFC jurisdiction so far as the principal WFO is concerned, there is nothing that can be seized upon which is susceptible or amenable to execution so far as the ancillary order is concerned either. And we said, paragraph 46, that was an obvious line of argument which any defendant in the position of R3 and R2 would take, and the court should have been alerted to it. Paragraphs 47 to 51 cover the delay point, and Your Honour has the dates. I've covered that ground. Paragraphs 52 to 54 deal with the disclosure orders. We have made disclosure, but we say that the freezing orders should never have been granted in the first place and should be set aside, and therefore the disclosure orders should formally be set aside too. And really the conclusion of the setting aside of the WFO and the disclosure orders is that both R3 and R2 should be removed as parties and names in these proceedings. Your Honour, those are my submissions. May I again just ask for 2 minutes to check with my co-counsel in Dubai?
Yep.
I'm obliged. I'll switch my mic off and camera off. Your Honour, I'm very much obliged, and I apologise if it was a slightly indulgent 2 minutes, but I do have 2 further pages which I should take the court to. Could I first, they're at 6427 and 6428. Just to identify what the document is, if the court goes to 6426. Your Honour will see that this is HMR Investment Holding financial statements for the 31st of December 2022. And then going down to page 6427, the company has incurred a net loss amounting to 2.79 million dirham, and then going on to 6428, we draw attention to note 2A to the financial statements, which indicates that the accumulated losses amounted to 16 million dirham as at the reporting date. Now, I accept that that does not show how that loss was funded or supported, but it has featured in the spreadsheet which we looked at, or at least an accumulated loss for HMR also featured in the spreadsheet at 4409. So what we say is that HMR is in fact in the position of net debtor rather than having any credit balance, and therefore even if D2's even if there is traceability, contrary to what Brodel says, even if there is traceability and susceptibility and amenability of D2's, in inverted commas, assets being available to satisfy a judgment debt against D1, on the present facts, D2 actually has no assets to satisfy that judgment debt. And then we go back to the Brodel analysis and apply it to R3 and R2 and say, A, there's nothing there when you look at it really apart from a very small net profit. Even if you take the cash at hand, there is no indication that that is other than in the ordinary course of business, and therefore again that is neither susceptible nor amenable to execution. Your Honour, I'm grateful for the short time that I was given to provide those 2 further page references.
if you go to page just 2 pages further on,
Yes.
6431, which is it's the same as 6909 we were looking at earlier, in fact, isn't it? But no matter. We've got a assets of 139 million.
Yes.
Non-current, current total assets 141. And then if you look in the liabilities, shareholders' current account is 145 million. So that's that's D1 being referred to, isn't it?
Yes.
So there are no significant loans other than what is in the shareholders' account. Current liabilities are relatively limited. You've got the accumulated losses appearing again.
Yes, you have the same accumulated loss which we saw in the note
16.
2 or 3 pages previous. Yes. And then the liabilities, I'm just looking to see what note 15 says, but obviously due to a related party. So the picture is not totally clear to the last dirham as to who owes what to whom, but it does clearly demonstrate in my submission that HMR investment has accumulated losses and owing to sums owing to a related party. So it is in the position of being a debtor rather than having any assets, which goes to the intermingling point, Your Honour. And due to related party probably means R1 rather than R2 or R3. I accept that, but it doesn't detract from the overall picture of what, if anything, the claimant could get from D2.
Right. All right. Thank you very much.
I'm obliged, Your Honour.
Mr. Anderson, where are we now? 11 o'clock UK time. I don't need to hear you on any issue about full and frank disclosure.
I'm grateful, Your Honour.
I need help on the same questions that I asked Mr. Patrick Joyce about assets available for execution, risk of dissipation, and the failures by the respondents to give disclosure that they ought to have given, as you say, under the disclosure order. And then I need help on the utility of a worldwide freezing order in the light of the asset position of both R1 and R2, particularly in the context of the properties, the City Walk and Polo residences, and their value as held by D2, and as you say, on your case at least, for the benefit of D1. So I don't know if that helps you much as to where you need to go. But in relation to that last point also is the question of the utility of a disclosure order as opposed to a worldwide freezing order in the light of the various other matters that I've raised with you. Does that help?
That's a very helpful indication, Your Honour. Thank you. And before
could I just clarify, when you said in the course of that, you referred to R1 and R2.
Oh, I meant
R1, then R2 and R3.
Right, quite right. Yes, R2, D2. Yes.
Yes, we do have an R2D2 here. Yes. Yes, Your Honour, I'm very happy to address those questions in the course of my submissions. Before I do so, just on a housekeeping point, were you anticipating a short adjournment at any point? And
well,
so,
it just depends. A bit depends on how long you expect to be. I'm conscious of the court staff. You know, from their point of view, we're talking about what are we now, 2 o'clock Dubai time, so that if we were to take a break, now might be a convenient moment from their point of view. But a little bit depends, as I say, roughly how long you think you might be. And then, of course, Mr. Patrick Joyce might want to say something in reply. But given the way these things go, with a burden on you, in a sense, to establish continuance of the injunction, you know, I'm not going to really insist on who has the last word, as long as everybody's happy they've been able to say what they really need to say, and I'm content that I've heard everything I need to hear. Any thoughts as to how long you might be?
I'm grateful. I certainly no more than 2 hours, and if it helps, very happy to have a shorter adjournment now, perhaps picking up before midday UK time, with a view to my finishing within somewhere between 90 minutes and 2 hours, giving enough time before 5 p.m. Dubai time for any last minute bits. And I assume within this, Your Honour, that you will be reserving judgment as well, rather than handing down. Well, we may need to factor that in as well.
Well, I shan't give a reasoned judgment today. It may be that I would be able to tell you what the decision is, but not with reasons to follow. But that we'll wait to see. But yes, we don't. No point in trying to factor in a reasoned judgment, because it needs expressing in a manner better than I would be able to do simply on an extemporary basis, whichever way I go with it. All right, let's take a break now then. Is that amenable to the court staff? Would that work for you?
Yes, of course. Yes, of course, Your Honour.
How long would you like? Would you be happy with a shorter period of half an hour?
That would be great.
Right, well, let's do that then, Mr. Anderson. We'll take half an hour now, and then that'll enable you to reorganize your thoughts for the particular points I need addressing, which on the whole I would have thought ought to be capable of being dealt with in an even shorter time frame than the 1.5 hours you've indicated. But as you've seen, I tend to interrupt, and things therefore take longer than they otherwise might.
Yeah, that's quite all right, Your Honour. I mean, it is probably the case that I can cut out some of what I was planning to say on the evidence of risk of dissipation, particularly with regards to the evidence that was before you at the ex parte hearing anyway, which you'll have firmly in mind.
Right. All right. Well, we'll take half an hour out now, which means we'll start again at 11:40 English UK time. Great. Thank you very much. Yes, sorry to have kept you. Is Mr. Patrick Joyce there?
Yes, I am, Your Honour.
Very good. All right. Thank you. Yes, Mr. Anderson.
I'm grateful, Your Honour. I thought I would begin by providing you with a short answer to those questions that you asked me prior to the short adjournment before developing them chronologically, as it were, in my submissions. Starting with the law and the legal test that you're looking at in this case. In my submission, my learned friend has got this wrong, and he referred on a number of occasions during his submissions to traceability. But traceability is not the test that the court applies when looking at granting a Chabra injunction. What the Court of Appeal says in Lacatamia, quoting Mr. Justice Popplewell as he then was, is that there have to be good prospects of showing that there is some process by which the judgment is enforced. That's the language that the Court of Appeal endorses. And the key error that my learned friend falls into is that language of some process doesn't always or inevitably have to depend on showing a continuing equitable interest or a tracing claim in the property. It can encompass both direct and indirect methods of enforcement. And I'll take you to the authorities on this, and in particular, quite a helpful note from Stephen G on the Brodal decision, which in my
that appears from paragraph 88 of the
of broad idea, exactly.
Broad idea, yeah. And to be fair, I mean, I think it was me who was putting it to Mr. Patrick Joyce that tracing was a possibility here because of the mingling of assets.
It is, and the G note is helpful, Your Honour, because it sort of summarises some of those other processes that can be used to satisfy that test. And those include things like being able to appoint receivers over shares that the judgment debtor owns, and the receivers then taking steps to recover assets on behalf of the company to protect the value of the company's shareholding. And that isn't a situation where there is a sort of direct tracing or equitable claim. But we say that is exactly what the case is here, is that there are assets that either belong to Mr. Rashed because of our nullity claim, or else they belong to HMR. And in the latter case, there's currently millions and millions of dirhams worth of rental proceeds being generated that are being paid on behalf of the company, ultra vires the company. The company's made no decision to make these payments to third parties, which the company would be entitled to claim back by any number of methods of claim at common law, whether common law or in equity or statutory or otherwise. There's simply lots of options that we have before us to claw back those transactions, the proceeds of those transactions, to protect the shareholding. So that's the point I want to deal with in relation to the law. And in my submission, Brodal doesn't assist you on that because it's not a Chabra case. It's all about how the court should properly interpret the commercial court wording of the standard form English freezing injunction, and the debate as to whether or not that can apply to the assets of a company which is owned 100% by the judgment debtor. So that's the short answer on the law. In relation to the assets, I've just touched on this point. We have clear evidence before you that these properties are generating millions of dirhams worth of rental proceeds every year. But we have no sight of where those rental proceeds are going. And what the evidence that Ms. Mansour has put before the court suggests is that HMR itself doesn't have a bank account. Royal View, according to Ms. Mansour, Mr. Rashed's company doesn't have a bank account. And it's RBM, Ms. Mansour's company, which is in theory acting as the sort of pot, as we would put it, the wallet in respect of all of these transactions and these rental proceeds. But at the same time, in her disclosure affidavit, she says that RBM's bank account doesn't hold more than $10,000 worth of monies. And we say that those two facts are just irreconcilable. And you haven't been given by Ms. Mansour any contemporaneous documents to assist you with reaching the conclusion that either her or RBM are not holding monies generated from the properties. And in those circumstances,
do we have any bank statements from RBM at all?
No. There's not a single bank statement that we have seen from either RBM or Ms. Mansour. which, had they existed, would very clearly prove the receipt or otherwise of rental proceeds from properties currently held by HMR. And you don't have that before you. And we say that that is a very stark omission from the evidence. Thirdly, Your Honour, you asked me about risk of dissipation. Just covering this quickly, you will have seen in my skeleton the points we rely on in relation to this. Firstly is that second and broader power of attorney, which Ms Mansour did not volunteer in her initial disclosure affidavit. We say that's clear evidence of a risk of dissipation because it gave her extremely wide powers of disposition and was executed after Your Honour had made freezing orders against Mr Rashed, the clear inference being that it was a vehicle for dissipation of assets. That is one factor. We rely on the absence of any funds that have been sort of identified or disclosed, notwithstanding the levels of rental proceeds which are being generated by these properties. And of course, the intermingling and the closeness of the relationship. And in particular, I'll take you to one part of the relevant accounts showing that RBM is treated for accounting purposes as a related party of HMR, which must mean that it's either subject to common ownership or common control. And given that RBM is owned 100% by Ms Mansour, the inevitable inference is that HMR and RBM are subject to common control in the form of Mr Rashed. That is what the accounts suggest. That's risk of dissipation, Your Honour. And I think the next question you asked me was about the deficiencies in Ms Mansour's disclosure. I'll go through that in more detail by reference to her affidavit. My learned friend took you to it. You will have seen that of the 7 or 8 pages of that affidavit, less than 1 page was devoted to actually providing disclosure as required by Your Honour's orders. Most of it was a vehicle for arguing the case. But we now have concrete evidence that what was said in that disclosure affidavit was not complete. And to take one example of that, Ms Mansour's evidence is that neither her nor RBM have been receiving monies on behalf of HMR, but we've very recently discovered from an email from one of the tenants in the buildings that checks are being made out by the tenants as recently as last month in the name of RBM to the tune of several tens of thousands of dirhams. So what is clearly going on is that tenants are still being directed to pay monies to RBM, notwithstanding the terms of your order in January of this year, divesting Ms Mansour of any role in HMR. So those are the disclosure points. The final point you asked for our submissions on was utility and the utility of granting these orders. And in my submission, Your Honour, it would be a sorry state of affairs if the court concluded that there was no utility in granting these injunctions, because in essence, it would mean that Mr Rashed had successfully dissipated these assets, or as a result of Ms Mansour not having disclosed information which would assist the court with showing the proceeds of where these significant sums of rental sums are ending up. But also, Your Honour, you know, these rental sums are not insignificant. I think it's somewhere around 7 or 8 million dirhams a year of rental proceeds are being generated by these properties. That we have discovered so far. I should caveat everything by saying, obviously, we don't have the full picture, and this is what we've been able to piece together in the face of stubborn resistance from the defendants and the respondents. But those are significant sums, and had they been being paid to us since we got our judgment back in 2016, the judgment debt would have been extinguished by now. But they undoubtedly affect the value of the shares, and of course now the extant execution process over those shares, which is on foot. You know, to put it another way, my client isn't going to be able to get somebody to buy these shares if there is a concern that the income stream from the properties owned by the company is just sort of being freely dissipated and interfered with by third parties. So it really is a question of sort of protecting the court's enforcement jurisdiction over that extant execution process vis-a-vis sale of the shares.
Well, that comes back to your basic point about rental and so on, where you'll have to take me to the accounts again and explain what's going on in terms of rental profit, as Mr. Patrick Joyce puts it, as compared with rental stream.
Yes, indeed. And one of the stark features of the most recent accounts is that the profits are eaten into to a very large extent as a result of related party transactions. And we do not accept that those are bona fide related party transactions, and we don't accept that you've been given sufficient evidence to conclude that that is correct. You have nothing before you other than Miss Mansour's unsubstantiated assertions that there are arm's length commercial deals between those parties. And we say, in light of all of the background circumstances to this litigation and these assets, that is a stretch, to put it mildly. So, Your Honour, with those sort of preliminary answers given, I was just proposing to say a couple of brief words about some of the overarching points that we rely on. I'll do so very quickly before then moving into the law. Two sort of underlying facts, undisputable underlying facts, are that one, we've got our non-appealable judgment, and two, we have our freestanding DIFC court judgment. Those two facts are indisputable. Third, what we now have is a situation where freezing orders have been made against not only the judgment debtor himself, but also the company of which he is or previously was the 100% shareholder. Now, that latter point is important because much of the jurisprudence that my learned friend seeks to rely on, in particular Brodau, concern whether a standard form freezing order can capture assets owned by the respondent's company on the basis that the wording says it covers assets that are under the control of the respondent. And that is not the position here. Your Honour doesn't have to get into that debate at all, and it's quite a lengthy debate in the jurisprudence on this. Your Honour doesn't have to even step foot into that arena because you've already made a freezing order against the 100% the wholly owned company, HMR. So we are one step beyond what all of these cases are looking at in terms of whether or not a standard freezing order can bite against a judgment debtor's company's assets, because we know that is already the case here. There's a freestanding freezing order that applies to those assets. So that's one point. And then the sort of final overarching point is one that I've alluded to before, which is that we have, in this case, an extant execution procedure on foot in the form of the sale of the shares. So title to the shares has now been vested in my client. My client's agent is now the director and the company secretary. And it might help, Your Honour, just briefly to turn up the order that you made in relation to this execution procedure, which is at page 3693 of the bundle. In fact, it begins at 3691, but the operative page is 3693. Does Your Honour have that?
I think so.
I'm grateful. It should be your order for sale, dated
right.
18th January 2024.
8th of January. Sorry, give me the page reference again. 3693, was it? Yeah.
That's right, Your Honour. Yes, 3693.
Yeah.
So Your Honour will recall that what was ordered was that the paragraph 2, the shares shall be sold, and you later modified that because we need the court's permission now before we effect the sale. But the shares shall be sold. The agents will have conduct of the sale. To enable that, we get title to the shares, and the agent, paragraph 5, this is the important part, the agent shall be appointed with the following powers to assist them in the proper discharge of their functions for the conduct of the sale of the HMR shares. And then if you just cast your eye down those 5 powers, and especially 5E, to do all such other things as may be necessary for the realization of the amount secured under the final charging order. So that is the extant execution process which these orders which we are seeking are aimed at protecting. It's at the agent's ability to properly realize the amount secured under the final charging order through the sale of the shares. And we say that must obviously encompass the ability of the court to assist the agents in getting in the property of the company for the purpose of protecting the value of its shareholding. And if that weren't the case, that would severely undermine the efficacy of the court's order of sale. And in fact, we go further and say that what the evidence shows is that Mr. Rashed and Miss Mansour have essentially been acting at all times to try to stymie this order and to prevent the agents from doing all such other things as may be necessary for realizing the amount secured under the charging order, viz. selling the shares at fair market value.
Yeah.
So those are sort of a couple of points of underlying facts. Then just 2 or 3 more points before I move into the law, which in my submission are sort of relevant to each stage of the test here. The first is obvious, is a short and obvious one, is Mr. Rashed's status as an unpurged contemnor and a prolific unpurged contemnor. We don't just sort of make that point repeatedly, on a gratuitous basis. It's fundamental the way that the court has to approach the evidence that's filed in these applications, especially where what you're being asked to do here is accept the evidence of somebody who, by her own admission, has a very close relationship with Mr. Rashed, to the extent of acting in a fiduciary capacity for him under the terms of 2 powers of attorney. Not only that, of course, but in circumstances where their affairs are mixed up and bound together through the use of single bank accounts across their various companies and businesses. The sort of one sort of high watermark of that submission, if I can put it that way, is what was said previously by Mr. Rashed's previous legal representation about how this litigation was being funded on his behalf. And I might just ask you briefly to turn that up, if I may, because it is quite a stark piece of evidence that shows the linkage between Mr. Rashed and Miss Mansour, notwithstanding Miss Mansour's passionate attempts to distance herself from him and try to give the court the impression that this is all arm's length commercial transactions. If you turn, please, Your Honour, to page 4424 of the bundle. And does Your Honour have that? It should be an email dated 14th September 2023 from Charles Russell Speechlys.
Not yet.
I'm grateful. Shall I? It's only a small piece of text. Shall I read it while it's
Yes,
waiting
go
to
on.
come up?
Read it out while I try and get there.
This is the source of funds notification, and you'll recall that under the terms of your freezing order, Mr. Rashed and HMR were obliged to tell us where they were going to get funds to spend on living expenses and reasonable legal expenses.
Yes.
Incidentally, you made the same order in relation to Miss Mansour and RBM in this case, but we've had no source of funds notification from either of them, just as an aside. So we don't know how they're funding this litigation, notwithstanding the terms of the freezing order. But what this email from Charles Russell Speechley said was that we confirm that our clients, i.e. Mr. Rashed's, legal fees in connection with this matter shall be paid by a third party, Royalty Business Management, DMCC, on his behalf. We understand that there is at present no arrangement in place for RBM to be reimbursed by our client. However, to the extent that that position changes, you will be informed. So the point we make in relation to that, Your Honour, is that it's rather unusual, to put it mildly, that an arm's length attorney or fiduciary would gift hundreds of thousands of dirham to their principal in support of their litigation. And of course, my client is acutely aware of how expensive this litigation is. These are not small legal expenses that are in play here, with no promise of reimbursement. So I just highlight that as a good example of the linkage between Mr. Rashed and Ms. Mansour, and the submission that I'll be making that you ought to treat Ms. Mansour's evidence with caution where it's uncorroborated by contemporaneous documents for various reasons, including her clear linkage with Mr. Rashed, who is an unpurged and serial contemnor.
Yeah.
So I think that covers the preliminary points, Your Honour. And with that, I just wanted to say a brief word about the legal principles. I don't want to waste time on this, but could I just ask you to very quickly turn up the relevant passage from Lacatamia, because it will make good my point about the precise wording of the test that is in play here. It's page 4591 of the bundle. And it's paragraph 32 of the Court of Appeal's judgment, which quotes and endorses the judgment of Mr. Justice Popplewell, as he then was in the Maximov litigation.
Yeah.
And it's just that paragraph 1 to sort of emphasize this point. It's that it's obviously good reason to suppose, and I'll come on to that, but it's the phrase would be amenable to some process ultimately enforceable by the courts by which the assets would be available. So Your Honour picked up the point earlier that it's the same thing that the Privy Council says in broad idea. It's not intended to be a sort of prescriptive test of establishing traceability or the subsistence of equitable proprietary interests. It's intended to be a flexible jurisdiction. It's some process which the court can oversee by which the judgment debt will be enforced. And that is important in this case, because we say that even if Ms. Mansour's case taken at its highest did show that there was no sort of subsisting equitable interest in monies paid to her or to RBM, nevertheless, we still have a claim by HMR, which is now in the claimant's control, to recoup those monies because they have been paid without the knowledge or consent of HMR in breach of its constitution, by way of unlawful interference with property rights, by way of possibly a conspiracy as well. So it's an important point to emphasise. Just in this context, to pick up one point, I think Your Honour mentioned this when my learned friend was making his submissions, but there was a suggestion in my learned friend's skeleton that you weren't told that this was a jurisdiction that should be exercised with caution, and that was wrong. The transcript did show that Mr. Holloway took you to the entirety of this paragraph of Lacatamia and expressly stated that it was an exceptional jurisdiction. So to the extent that he maintains that submission, I would ask my learned friend to withdraw it. But then that brings us on to Brodal and what we say about Brodal, Your Honour. And my learned friend goes as far as saying that we acted in breach of our duty of full and frank disclosure by not referring to this decision at the ex parte hearing before you. But in my submission, when one goes through the facts of this case, it really doesn't move the dial at all in terms of your analysis of the relevant principles. And I would just like to spend 5 or 10 minutes or so just quickly running through the reports to make good that submission, if I may.
Well, I'm not sure that you need to, really. As I say, the relevant principles remain the same as established in Lacademia and Broad Idea, don't they? And
precisely. And I suppose the essence of our point on Brodal is that it's not a case in point at all, because it concerned whether or not the court would make a declaration as to the ownership of assets under the standard form freezing order. So the undertaking in that case included the usual form of words to the effect of assets, whether or not owned legally or beneficially, whether or not under the control of the judgment debtor, etc. I'm paraphrasing, but you're almost familiar with the words. And the question for the court was simply, on the facts of that case, do the relevant assets fall within that wording? And the court held that it wouldn't make declarations to that effect on those facts. But that is a far cry away from this case, where we're not concerned about that at all, because we have a freestanding freezing injunction against the company. So, as Your Honour has identified, really, we're just looking at the Broad Idea Lacademia point, which is there some process by which the judgment can be enforced? And just on this question about the enhanced standard of arguability, I don't understand my learned friend to be submitting that phrase has changed the test from Lacademia, but it obviously cannot and does not. The test remains good reason to suppose. And as Mr. Justice Popplewell made clear, that is to be equated with good arguable case, i.e. more than barely capable of serious argument. So it doesn't move the dial in that sense. I mentioned just to make good that point as well. We've conducted a search on both Westlaw and Bailey, and that appears to be the only case on both of those databases that even uses that phrase, enhanced standard of arguability. So in my submission, that phrase doesn't add anything to your Honour's analysis. But I mentioned earlier, Your Honour, the Stephen G article that I submitted. It would be helpful to take you to, and in my submission, this is really the final nail in the coffin on this point about traceability, which my learned friend focused on, because what Stephen G does is just set out in broad terms some of the other methods of enforcement that are permissible under the Chabra jurisdiction, and it's at page it starts at page 9390 of the bundle, Your Honour.
Is this from his book, or is it a separate article?
No, this is an article that he wrote almost immediately after the decision came out, in which he said that it's wrong. So it's from the Civil Justice Quarterly, I think. But it is the same author as the textbook.
Yeah.
And so there's just a couple of excerpts I wanted to point Your Honour to. The first is on page 9392. It's about halfway down the page, and there's a paragraph that begins, the fact that the debtor is 100% shareholder and sole director of a company is normally sufficient to establish that the enforcement principle is satisfied for company assets, because execution on and sale of the shares.
I'm sorry, which page are you actually on?
I'm so sorry, Your Honour. It's 9392. It's page 3 of the article. It's about halfway down. It begins, fact that the debtor is 100% shareholder, etc.
Yes,
because
got it. Yeah.
Execution on and sale of the shares will realise a price depending on the value of the company's assets, or a receiver can be appointed who can use the shares to vote declaration of a dividend or put the company into liquidation. And of course, the corollary of that latter point is that the liquidator then has available to them all of the statutory abilities to claw back unlawful dispositions, whether that's as a result of wrongful trading, fraudulent trading, or preferences, etc. So in my submission, that's a good summary of the position that we're in here and the routes available to my client in circumstances where we have this extant execution process ongoing over the sale of the shares. And it's imperative in my submission that this court acts to protect the efficacy of that process. And as a result, the enforcement principle in my submission is clearly satisfied on these facts. So what in terms of causes of action, I mean, what we're looking at here, Your Honour, are things like those insolvency claims. It may be possible, for example, for the company HMR to bring claims against third-party recipients of its property on the basis of unjust enrichment, because they have been paid out ultra vires the company without the company's knowledge and consent. And those claims would obviously result in the recovery of funds unlawfully paid out, which would swell the company's assets and, all else being equal, increase the value of the shareholding. So there's that aspect to it, but there's also the point I made earlier that it's not just about protecting and ring fencing the proceeds of the company's assets, but also making sure that this is a company worth selling, because there is clear evidence that monies that are being generated with properties that it's holding are being essentially misappropriated from the current shareholders and management. And then if you could just turn the page over in this article, just two more excerpts I thought might be quite helpful for Your Honour to look at. The paragraph over the page, about 3/4 of the way down, that begins, the judge recognised at 83, and that's a discussion of Preston Pressed. Could I ask you just to skim over that paragraph, Your Honour, because it helps make good the point I've just been making. And it's really those final two sentences of that paragraph, Your Honour.
Yeah.
So yes, as I say, it's those final two sentences. All of those routes for enforcement are within the enforcement principle as enunciated by the Court of Appeal in Lacatamia. None of them require the debtor to own beneficially the company's assets, and by extension be able to sort of demonstrate a continuing subsisting equitable interest or a tracing remedy. It's one method of satisfying the enforcement principle, but it's by no means the only method.
Yeah.
So, Your Honour, unless I can assist you further on that, that was all I planned to say about the legal principles. It strikes me that it's relatively uncontroversial that what you're looking at is a much broader possibility of enforcement than Brodal might have suggested. So what I then intended to do was just very briefly take you to a couple of the points that were relied upon by the claimant at the ex parte hearing before you as justifying the relief sought, and in particular demonstrating real risk of dissipation and satisfaction of the enforcement principle. We summarised those at paragraph 36 of our skeleton, and I won't take you to all of them, but I'll just take you to a couple of the points that are relevant in light of what Ms. Mansour has said in her evidence in support of her application. The first of those concerns the timing of the change of the bank accounts, the HMR's bank account. And the reason I want to take you to this is because it contradicts Miss Mansour's unsubstantiated assertion that Royal View's bank account was closed in early 2019 as a result of a sort of unparticularized sanction policy, of which your lordship is given no documents and no further assistance. So what you were shown by Mr. Holloway at the ex parte hearing was the bank accounts for the years preceding 2017, which showed HMR operating its own current account. You can see that, for example, at page 4255 of the bundle, Your Honour. You might not need to turn to it. It's just the 2017 accounts, and it shows bankers' information, Mashreq Bank, and there's a current account of euro, sterling, and dirham. That was the bank account that HMR owned for the year ending 2017. But then if you turn to 4276, you will see that for the following year, i.e. year ended 31st December 2018, after our judgment has become final, the bank is changed to Royal View's Bank, National Bank of Fujairah, registered in the name of Royal View Trading. It's a dirham current account. And of course, what we now know, what we didn't know at the ex parte hearing, but what we now know is that, in fact, Royal View is a company which is 100% owned by Mr. Rashed. And that wasn't something that we were able to confirm before you at the ex parte hearing, but we now know that to be the case because Ms. Mansour says so in her own evidence. We made the point in relation to these accounts that the Polo residence units also appear to have been gratuitously transferred as well, but I don't need to take you to that. Your Honour will have that firmly in mind. But what we also relied on in the context of these accounts was the level of income being generated, and the corollary of that being the total absence of explanation as to where that money is going. And you can see that, Your Honour, if you just have a quick look at the year-end 2020 accounts at page 4387 of the bundle. And if Your Honour has that, you'll see on this page that at the top.
I didn't have it yet. Have you got the section number by any chance, by reference to the key on the left of the case lines?
I can get it for you, Your Honour. I do have the index. It should be.
I'm afraid the things sent to me by the courts don't assist because
it's section AB. And it should be the third tab, I think, Your Honour. It's part of Mr. Vestiso's exhibit to his fourth update. Yes. Yes, KB6, yes.
Yeah.
And if Your Honour has it, it's page 4387 of the bundle.
Tell me what it says while it's coming up.
So what it says, Your Honour, is that for these are the draft accounts for year end 2020, and the rental income was just shy of 8 million dirham. That's the rental income, up from 5 million the preceding year. So not insignificant sums by any stretch. The cost of income in relation to those rental proceeds is just under 3.8 million. So the gross profit recorded there is 4.1 million dirham. But then the way that that ends up going from a gross profit to a net loss is that 3 deductions are made from it. The first is expenses, and I'll show you the what is meant by expenses. But then the next 2 significant line items that reduce it to a net negative figure are depreciation. You've got depreciation on fixed assets and depreciation on investment in properties. Now, from our perspective, we can't really understand from an accounting perspective why depreciation would sort of eat into profits in that way. Nor does it mean that the monies that have therefore been generated are sort of dissipated. The money is still there, but as an accounting policy, it's just declared as a loss because there's depreciation on the buildings. But that doesn't mean, and this sort of meets the point that my learned friend made, that there's no utility to these injunctions because the company's not making money anyway. Well, perhaps on a very pure accounting basis, it's not, because it's employing what seems to be quite a hefty depreciation policy on its assets, which are in each instance completely eroding its profits to a loss.
Is there any comments in the notes to the accounts about the basis of depreciation?
Yes, that was what I was just about to take you to, or at least in relation to the expenses. Does you want to have that now?
I'm afraid no. It's still going round and round in circles in the most annoying manner.
Well, let me just bring up the notes that meet that point.
Let me try and get it the other way. It's come up. Right, I'm looking at 4387 with the gross profit of 4.181.
Yes.
Where do you want me to go next?
Your Honour asked about the depreciation policy. That's on page 4396. And it essentially says, if you look about halfway down in relation to investment properties,
straight line method. Oh, right.
Straight, exactly. It's just a straight line basis. So it's not as if the auditors are applying a sort of a yearly calculation to work out how much those buildings are depreciating by. It's just a sort of straight line basis with an estimated useful life of 30 years. So I don't go as far as sort of completely impugning that as an accounting policy, but what I do say is that Your Honour has to have some caution when hearing the submission made by my learned friend that what these accounts show is that the cupboard is bare, to use his phrase, because when you sort of dig down into the accounting policies and look at what's going on here, it doesn't follow inexorably that from these accounts the cupboard is bare. What follows is that there's a balance sheet loss, but that doesn't mean that there isn't rental proceeds somewhere sitting in a bank account. And we would say that must obviously be the case, because the only reason that gross profit turns to a net loss is because of that application of the depreciation policy. So that doesn't affect the fact that there's money sat in a bank account somewhere. And the only other part I wanted to show you on these accounts, Your Honour, was the other aspect that limited or reduced the gross profits, which is the related party expenses. That is at note 16 on page 4406 of the bundle. Right at the bottom of the page, Your Honour.
Sorry. Yes.
So 4406, you'll see at the top of the page, Your Honour, there's the definition of related party transactions. And that makes good the point I made at the beginning of my submissions that related party is where the company has the ability to control, etc.
Familiar stuff.
Exactly, familiar stuff. And what is said at the bottom, that part of these expenses that eat into the gross profits are firstly reimbursements of expenses of a related party, and secondly other administrative expenses. Now we assume that the latter are probably expenses that go to entities like FAM, who are performing management roles in respect of the relevant properties. But the former is obviously a reference to monies that are going to either Royal View or RBM. Now it's important on that point that I make good this, that both Royal View and RBM are treated by the auditors as related parties within that control definition. And you can see that if you turn a few pages over to page 4409, going back to this very small sheet that we've looked at already. This is in fact it's the trial balance for HMR, is what this document is.
Ah, right.
And we don't dispute Your Honour's point that there is going to be limited utility at looking at this in relation to the current financial position of all of these entities. But what we rely on is right at the bottom of the page, 4 and 5 lines up from the bottom of the big box. You will see that it says related party reimbursement of EXP expenses, RVT, Royal View Trading, and then immediately below that, related party reimbursement of EXP RBM. So both Mr. Rashed's company, Royal View, and Miss Mansour's company, which she owns 100%, RBM, are treated by HMR, by its auditors, as subject to the control of a common controller, namely Mr. Rashed. And that's an important point, Your Honour, when it comes to risk of dissipation, because we say that what these documents show is that Mr. Rashed does clearly have control over this single pocket, this single kitty of funds, and is able to direct those funds however he pleases. Just 2 more points briefly, I think, Your Honour, from the ex parte hearing that we relied on. One of them was, you'll recall, we referred to the fact that after you made the order, the sale order, by which we then appointed agents as the directors of HMR in around mid-February, we'd found evidence that leases were still being registered and continued to be registered, notwithstanding that only the claimant's agent ought to have had capacity to do that. And we showed you, or Mr. Holloway showed you at page 4369, an Excel spreadsheet that had been obtained, I think, from the Dubai Land Department, showing the registration of leases in respect of the Polo Residence building. And you may recall, Your Honour, I don't think you need to turn it up, but there was at least one lease we found that had been executed at the end of March 2024. Now, we said that showed a clear, for want of a better word, contempt towards the DIFC court's order by Miss Mansour, because she had been the one who was liaising with FAM, according to Mr. Paciso's evidence. What is said now on behalf of Miss Mansour is that, in fact, she didn't know about this order until, I think her evidence is sort of mid-April. She wasn't aware of the terms of this order. But, Your Honour, we say that that's simply implausible in circumstances where, by her own admission, she's essentially running this litigation on Mr. Rashed's behalf. That order for sale was served on Charles Russell Speechley's after it was made, and it was made some 3 months before Miss Mansour says she became aware of it. So we say it's just simply implausible that she wouldn't have known about that order, and that the better view is that she was simply flouting it because she does not consider that the DIFC courts have the power or jurisdiction to vest the shares in someone other than Mr. Rashed, which is a point which has been raised repeatedly on behalf of both Mr. Rashed and Miss Mansour. So that was that point I wanted to briefly raise to counter what was said on Miss Mansour's behalf. And then the final document that importantly you were shown at the ex parte hearing was the income and expenditure report for RBM. And I don't think we've looked at this document yet, so it might be worth just refreshing Your Honour's memory. It's at page 4411 of the bundle.
Sorry, page again.
4411, Your Honour.
Thank you.
And while you're getting that up, you'll recall that this is the it's the income and expenditure report for RBM, but it was given to us by HMR's auditors, who told Mr. Besiso that it was essentially used as part of the preparation for HMR's accounts. And you'll recall, Your Honour, that Mr. Holloway took you through a number of these payments that are recorded in this document. Does Your Honour have that?
Yes.
Yes. You'll recall that Mr. Holloway took you to a few of these payments, showing things like, on page 1, large payments received from FAM on the 23rd of December of over 230,000 dirham. That's in the middle of the page, received from FAM Living in respect of what is described as a profit share. And then there is also rental income received, that's sort of mentioned in one of the right-hand columns, rental income from City Walk buildings, CW buildings, and also from Al Fatan as well. And does your Mr. Holloway was testing your memory at the ex parte hearing? I'm now testing your memory at this hearing.
Yeah, that's where he lived. Yeah,
exactly. And he mentioned in a witness statement that he owned properties there, but he never disclosed them. He's obviously never disclosed any of these properties. You know, that we managed to work out through some detective work that those properties are generating income, which is apparently paid into RBM's account. So that was what that document showed. And importantly as well, and this is important for the point in relation to that my learned friend makes about having to demonstrate separately in relation to each respondent the relevant conditions for relief. What this document shows is that at least for the year 2020, significant sums of money are being paid out from this RBM account to Miss Mansour. And what Mr. Besiso does in his affidavit is that he has worked out exactly how much money has come in from HMR properties and how much has then gone out, to establish that at least some of those payments that go out to Miss Mansour must have been derived from HMR funds, because otherwise there wouldn't be enough money paid into the account to make those payments, if Your Honour follows the logic. So if we, you know, if we have to get home on traceable proceeds, which I say we don't, that is sort of substantiates that point. But more broadly, the point that we relied on was that this is a single kitty, a single fund that is used to make payments out to all sorts of third parties, including Miss Mansour, and now is being done in circumstances where HMR is not authorising any of these payments. So to the extent that they are still being made, which we say you ought to infer they are, it's done ultra vires the company, and they are subject to clawback. So that was all I wanted to say on the evidence before you at the ex parte hearing, Your Honour. I think best then to turn to the disclosure affidavits and answering your question about what we say about these and how they are relevant to today's hearing. Would it help? It might help actually for Your Honour to just turn up again the actual terms of the disclosure order, just to remind yourself of the extent of the information that was ordered to be disclosed. It's at 4707. Your Honour.
I've got
and it begins a couple of pages later. And what Miss Mansour was ordered to provide was total sums she'd received from HMR, total sums received from Mr. Rashed himself, all steps that she'd taken as purportedly a company secretary, details of all leases, which ought to have been a straightforward request in circumstances where she was until that time company secretary, and the total sums received by RBM and Royal View from or on behalf of the second defendant. And you'll appreciate, Your Honour, that the reason that we included that was, as we've just seen, because of this commingling aspect, all of the money's being bound up together. And the whole point of that disclosure was intended to separate out these various strands so that the court could then assess this sort of traceability question and how much money has been received by each of these entities. But instead, what we'll see we've got is a sort of a brick wall response to this and a sort of blanket denial of everything. So that was what Miss Mansour was obliged to disclose in a personal capacity. Then Royal View and RBM were both obliged under paragraph 3 to disclose the same things. Now, but pausing there, I think Your Honour picked up the point earlier that Royal View has not given any disclosure in these proceedings and is therefore prima facie in contempt of court for having breached an order with a penal notice on it. What is significant about that is the fact that Miss Mansour, by her own admission in one of her affidavits, is one of the managers. I'll double check the exact wording, but she essentially is a manager of Royal View, and of course she has the power of attorney on behalf of Mr. Rashed, and this company is owned 100% by Mr. Rashed. So in principle, we cannot see any reason why that affidavit hasn't been given, and indeed no explanation for that, as far as we are aware, has been proffered by any of the respondents or the defendants as to why simply we don't have that information, why the court doesn't have that information when it ought to have been provided. And we say that is the more likely inference is that is not an accidental omission, but that the disclosure given by Royal View would assist us materially in following and or tracing the rental proceeds from these properties. So having seen that order, just before we move off it, Your Honour, obviously there was also the FAM as well. And that's important to remember because Miss Mansour tries to distance herself from FAM, but actually I'll come on very shortly to show you what they exhibit, which seems to completely cut across Miss Mansour's evidence. But what they were ordered to disclose was a collection of things like the total sums they had received in respect of rental proceeds. And obviously, Your Honour, we just saw that there was a quote-unquote profit share recorded in RBM's documents. And then details of payments that they had made from those rental proceeds to third parties, again, so that we could try and find where these rental proceeds go. They're also asked to give details of the tenants as well and the relationship between them and HMR, including any contracts that existed, sort of delineating the nature of their their role as property managers. That their affidavit is worth turning to first, because it is very bare. There is not much information contained in it at all, and it starts at page 6982 of the bundle. I do beg your pardon, Your Honour, it's 6981 it begins. And what they essentially say from paragraph 8 of that affidavit onwards is that they haven't received any money from HMR since 2019, and don't currently hold any sums or checks or monies. Now that's important, because I'll come on to show you that we've found checks made out to them very recently in respect of tenants of the properties. But that is at least what they say in this affidavit. But more interesting than what is said, or rather what is not said, is the statement of account that's exhibited to the affidavit, which is at page 6985. And what this document seems to show is income or monies generated from one part of City Walk 18A. And the interesting part from the perspective of this application is the final two lines: net due to owner and paid to owner for the years 2019 to 2024. Now, there's no definition of owner in that document. One assumes that it is Mr. Rashed, albeit given that the properties have now been in the name of HMR since 2019, it is feasible that those could be monies paid to HMR as well. As a result of the deficiencies in the disclosure, we just don't know where those monies have actually gone, how they've physically been paid out. But what's abundantly clear is that for the year 2023, for the majority of which your freezing order was in place, over 3 million dirhams has been paid to the owner, whether Mr. Rashed or HMR. Now that we say is obviously significant, because we've not been told about this and we don't know where those sums are. But prima facie, you have got monies being collected by the agents of these properties that are being paid either to Mr. Rashed and or HMR, but which the agents of HMR cannot locate and have not been able to find. So that is obviously significant in the context of risk of dissipation, when bearing in mind the connection with Mr. Rashed and Miss Mansour, which I'll come on to in more detail. But then we go to Miss Mansour's disclosure affidavit, which my learned friend took you through, and which is literally the following page, I think, or oh no, sorry, it's back a few pages. It's 6896. Now, Your Honour, my learned friend took you quite carefully through this affidavit, and I don't intend to do the same thing. You've already seen it. The headline points from our perspective are that this is essentially just a written submission. It's not an attempt really to assist the court with disclosure of assets. It contains a number of completely unsubstantiated assertions, such as in relation to the closure of Royal HMR's account and this bank sanction policy point, which we say isn't credible. And I'll come on, I'll just make a note, Your Honour, because I'll come on to show you that I think it's the 2020 or the 2019 accounts. The Royal View bank account is recorded as still being open. I think it might be HMR's 2019 bank accounts record that the Royal View account remains open, or at least that was the account used by HMR for that year, which is directly contrary to Ms. Mansour's evidence that it was closed in early 2019. So I'll make a note of that. If I haven't taken you to that, please do remind me, because it is an important point. But in any event, as I say, I don't intend to take you through all of this evidence because much of it isn't evidence. It's sort of points of submission and argument. There are just sort of a couple of points to pick out that are areas that are crying out for further explanation or for documentary proof, which Your Honour just hasn't been given. An example of which being paragraph 25 on page 6899. The fact that apparently there are many payable debts, including license renewal fees, bills and service charges, estimated annually at no less than 3.5 million dirham. You don't have any of the underlying documents in relation to those apparent expenses. So that's one example of that. The other I've already mentioned is the closure of the first respondent's bank account. I'll come back onto the power of attorney point towards the end of my submissions, if I may. But we made the point now, skeleton, you don't actually get onto the disclosure of assets as required by your order until the bottom of page 6. And then you have sort of less than a page of information. And that's in response to all of that detailed information that you ordered Ms. Mansour to provide, obviously for the purpose of assisting us in being able to trace, for want of a better word, the rental proceeds. And what's claimed, quite simply, is that Ms. Mansour hasn't received anything. She apparently hasn't dealt with any of HMR's assets since February 2023. That is stated at paragraph 38. Query whether that is or can be correct if she says that she didn't even learn about her not being company secretary anymore until April 2023. But what you have is sort of a series of just bare assertions which don't stack up when it's remembered that her role was company secretary. She sort of ought to have all of this information to hand, especially things like the rental agreements, the tenancy agreements, etc. But just does not provide them. So that, we say, is of really limited assistance to you. But then what is more helpful from the purpose of this application is the unsigned accounts for both HMR and RBM, which are exhibited to the statement. As I say, that Your Honour needs to exercise some caution with these because they are unsigned accounts, they're undated accounts, and also they have been prepared by a different auditor now to the auditor who prepared all the accounts that we looked at the ex parte hearing. But just going through these documents briefly, starting on 6905. This is HMR's accounts.
Yeah.
And it should state somewhere, I have a reference to it, operations being managed by a related party. Yes, so if you look under review of the business,
third paragraph down there.
Yeah, exactly. The company operations are managed by a related party and an external property manager. So its operations are managed by either RBM and or Royal View. And again, the language of related party, subject to the same control. Then you go to the balance sheet, and this is the point that Your Honour, I think, has already picked up, which is at 6909. That notwithstanding that Ms. Mansour is at pains to stress the sort of accumulated net loss of the company, the value of the investments was 140 million. and its balance sheet is net positive, and that's at 6909. And it's got receivables of nearly 2 million dirham, but curiously, nothing inserted for bank balances, presumably because all of its cash is held on its behalf by RBM.
Yeah.
So just then going to some of the notes. Yes. So to make good that latter point, it's 6924. You're on a note 9. And it says that the company does not have any bank account in its name. The company's operations are managed through a related party bank account. And then at 14 and 15, you'll see, again, significant related party expenses, both due to reimbursement of related parties and due from a related party about a third of the way down, 6925. So money's actually owed to HMR by either Royal View or RBM, according to these accounts.
Yes.
And then you're on a sort of pick this up before, but we see similar things in RBM's account. So sort of fast forwarding to page 6929. Some quite significant points here. If you look at results first, Your Honour, from the manager's report, the manager being Miss Mansour, she records, companies recorded a net profit amounting to 187,760 dirham for the year ended 31st December 2022. Yet, according to Ms. Mansour's evidence, it doesn't have more than $10,000 in a bank account anywhere. And then on the same page, under review of business, company was managing properties of a related party at fixed percentage of rental income as supervision fees. So what we say is going on here is that this arrangement in relation to RBM taking a cut, as it were, of rental proceeds is still ongoing, aided by the fact that both companies seem to use the same bank account. Notwithstanding that, since February of this year, when our agent was appointed, none of these payments of rents have been within the vires of the company. And then perhaps most damning of all, Your Honour, if you go to page 6932,
Yeah.
do you see cash and bank balances, 1.8 million dirham?
Yes.
And then highlighted accumulated profits of 362,000 dirham as well. All of this in the context of Miss Mansour saying that the bank account doesn't hold more than $10,000. And it actually, I think, would assist Your Honour to look at the note there, number 8, in relation to cash and bank balances, which is at 6932. Sorry, 6946, Your Honour.
Yeah.
And do you see?
Yes.
No.
Item 8. Yeah.
Yeah. Bank account is used for receiving rental income of a related party and its shareholder, and paying expenses for this company and other related parties. So it seems to us that there are only two options if on the face of these documents. Either Ms. Mansour is not telling the truth about what's in RBM's bank account, or that bank account has subsequently been emptied since the drafting of these accounts. And on any view, whatever permutation is correct, that is plainly a real risk of dissipation on Ms. Mansour's behalf, and also on RBM's behalf, where it is RBM's account that is in issue here. So there's those, and then of course I've made the point, Your Honour, that Royal View hasn't given us a disclosure affidavit at all. I'll find a reference for this for you, but in my notes I have the point that she has described herself as appointed as its administrative manager in June 2011, and has been paid 65,000 dirham a month in that role. But I will double check that to make sure that I'm not falling into the R1, R2 trap distinction. No, here's the reference, Your Honour. I've got it now. It's at the very top of page 6899. Paragraph 17 of Miss Mansour's affidavit. So apparently for the past 13 years, earning over $750,000 dirham a year as the administrative manager, and presumably in a position to give an affidavit on its behalf, but has decided not to do so. So, Your Honour, I think.
Can you just wait a second?
Yes, yeah, of course, of course.
Yeah.
I'm grateful, Your Honour. I think I can take the rest of the factual points relatively quickly, going through the other two disclosure affidavits and our recent discoveries. The first point to make is sort of moving chronologically on to Mansour 2. Only 4 documents or separate documents are exhibited to that affidavit. One of them is Mansour 1, the first affidavit. The second is the legal power of attorney. The third is the 400 or so pages that my learned friend took you to in relation to the city walk service charges. And then finally, there are sort of 3 pages, I think it is, of RBM's cash transactions for the year 2019. So against the evidence as I've set it out so far in this hearing, one might have expected a lot more than that to persuade the court that the commingling, which was so obvious at the ex parte hearing, is not in fact commingling and is in fact perfectly explicable by way of arm's length commercial bona fide transactions. But all you've been given by way of contemporaneous documents is the power of attorney, the service charge statement, and some cash transactions from 5 years ago. So we say that it's obvious, even before you look at the affidavit, that sort of evidence is not going to move the dial from where we were in May of this year. But then what is simply left are a number of unsubstantiated submissions in the affidavit, incidentally unsupported by a jurat. I don't know if you want to pick that up, but none of these affidavits are properly supported by a jurat either. And all of them, I would invite your Honour to treat with considerable caution for the reasons I've given, to the extent that they are not supported by contemporaneous documents. So just picking a 1 or 2 out, 6401, paragraph 14. The assertion is that neither Ms. Mansour or RBM even received any sums from Mr. Rashed or HMR since 2019. Well, that has possibly been very cleverly worded, because what we have now seen are checks made out to RBM for tenants of HMR's properties. So it might be said that isn't incorrect what is said there, because it's not directly received from HMR if the tenants are paying RBM directly, and I'll take you to those checks shortly. But certainly it's just another example of a failure to be fully frank and open with the court in relation to some of these points. Then, if you just turn over the page, just on this point about royal view, paragraph 22, you can see that what Miss Mansour there does is set out evidence practically on behalf of royal view in this affidavit, but of course we don't have the affidavit from royal view. And just picking up 1 or 2 other points, Your Honour. Paragraph 28D.
Mm.
6406. Financial reports show that any expenses reimbursed by R2 are not funded by D2's rental proceeds. Well, that's just factually incorrect. And I mentioned earlier that Mr. Basiso has done the calculations to show that mathematically, at least in 2020, and it is to be inferred subsequent years as a result of the higher rental proceeds being generated, funds paid out from the joint account, for want of a better phrase, to Miss Mansour must have included to at least some degree rental proceeds from HMR. Perhaps 2 more points on this. First one is paragraph 29H, which is page 6407, right at the bottom, Your Honour.
Yeah.
This is, we say this is a really good example of what can only be described as a pretty obtuse attitude towards providing this evidence. What we pointed out at the ex parte hearing that this joint account of RBM seems to be used to pay expenses at the Dubai Marina in relation to a yacht. And one would have thought that cried out for an explanation as to if neither Miss Mansour nor RBM own a yacht, what are they doing using funds in their accounts to pay for expenses in connection with a boat somewhere in the marina? And what is said in response to that point is, I've never owned a boat, nor has our royalty business management. These expenses are entirely unrelated to any assets or properties of HMR. So again, it's just a failure to be frank with the court. What the court should expect was a full explanation as to why RBM's own records recorded payments in respect of a boat, but that's just absent. There's no attempt to try and assist the court with points like that. And we've picked up a number of those sort of points in the skeleton. I don't want to spend time going through them all, but that's just a good example where we say Your Honour does have to be careful with this evidence, because in places it's just plain wrong, and in other places it is, we say, either very carefully worded or obtuse, in the sense that it doesn't answer the points that Your Honour will have firmly in mind on this.
But she does say elsewhere that RBM acts does management and supervision services for other clients. So
yes,
that is consistent.
Management. Well, property management is what she says, Your Honour. Unless I'm wrong.
Well, I'm looking at 23D simply says management and supervision services. It may be that you're right in saying, because it follows on from C, which says it's been engaged in real estate management and supervision services, that must be subject to the same.
It may be that the 2022 draft accounts describe the business, I think, as a property management business.
Well, they do, certainly. They do, but if you acted for a property owner who had a boat, it's conceivable
such as Mr. Rashed, for example.
Such as Mr. Rashed, or such as somebody else. So that on the face of it, I don't think you can draw much conclusion from 29H.
No, it's not. I wouldn't put it particularly highly on it. It's just, had that been the explanation, one might have expected that it would be freely given. But it's just odd, we say, that it's not.
Doesn't say that D1 never owned a boat.
No, tellingly, one might say.
Well, possibly. No evidence either way.
No, but for the purpose of good reason to suppose. I mean, we're looking at a case that is more than that is capable of more than seriously capable of more than barely arguable. And we say that there are a number of inferences that Your Honour is entitled to draw on the face of this evidence, which meets that relatively low threshold. I've just been informed by my instructing solicitors, Your Honour, that the note in respect of the payments on the yacht in that document in RBM refer to quote unquote RV yacht. RV obviously being an acronym for Royal View. And again, as a corollary to the point Your Honour just made, what is not said there is that View does not own a yacht. So there it is. I mean, as I said, I don't put that point too highly, but it is, in my submission, reflective of what is not, as my learned friend says, an attempt to be fully transparent with this court in relation to this evidence. Now, the final point on this is quite an important one. It's the evidence in relation to Royal View having not maintained bank accounts since early 2019. And the reference for that is at page 6414, Your Honour. It's paragraph 33B.
Yeah.
And if you look at that, what it says is that the account was closed in early 2019.
Yes.
I'm just trying to find you the reference to the 2019 account. 2020, I think it's in Mr. Basiso's affidavit. I can just try and find 2019. It begins on 4299, Your Honour. I think we may have looked at this. It's page 4301. But these are HMR's accounts for the year ended 31st December 2019. And what is said there at the bottom, bankers information, National Bank of Fujairah, AED current.
Yeah.
So difficult to see how that evidence as the account closing in early 2019 can square with the signed audited accounts declaring that HMR's bank account for the entirety of 2019 was Royal View's bank account.
Yeah.
I think in the interest of time, Your Honour, I'm not going to deal in too much detail with the third affidavit. You will have seen that the only documents exhibited to Ms. Mansour's third affidavit were the cancellation of one of the onshore enforcement files. This is a point I need to make. So this is a point that my learned friend relies on in support of his cupboard is bare point. Your Honour rightly picked up that actually that document doesn't really show much information as to why that execution file was closed. But in any event, it's important to bear in mind that that is only one of two execution files against both respondents. That execution file, which has been closed, was opened in response to Your Honour's disclosure order. And my instructions are that there is a separate execution file open onshore in respect of Your Honour's freezing order, which remains open in any event. So the closure of that file is not a panacea. It does not prove that there are no assets available for execution. It simply shows that that particular file has been closed with no reasons really given by the onshore courts. So with that, Your Honour, I just wanted to pick up 3 points in relation to recent factual developments. We'll just go through those quickly, and then that will conclude my submission, subject to any further questions from Your Honour. The first is the power of attorney. Now, Your Honour, you were taken to and you looked at what Ms. Mansour said in her affidavit about the power of attorney. Just to remind Your Honour of that, is at page 6408.
Yeah.
And then over the page. And in particular, the evidence that the power of attorney was strictly limited to representing Mr. Rashed in court proceedings, does not extend to any matters concerning control, management or disposal of assets, confined solely to legal representation, does not encompass any authority over financial or asset related decisions. And then going on, it's explicitly restricted to legal matters and lacks any agency characteristics or implication. So the message that was presented to the court was clear there. All Ms. Mansour is entitled to do is run some litigation on Mr. Rashed's behalf.
Yeah.
But then fortuitously, we discovered that there was a second power of attorney that was executed, which gives her precisely those powers, which she's very keen to stress to the court weren't contained in the legal power of attorney, if I could describe it that way. And that power of attorney is at page 6950.
Yeah.
And it starts at the bottom of that page. And what it gives the power to do is complete the sale, transfer, or ownership transfer of the following properties and collect the price. And then it gives a long list of properties, I think all of which are outside the scope of properties we knew about before seeing this. Importantly, including some properties in the DIFC, Your Honour will see on the next page, offices in the DIFC. But then if Your Honour just skips over that long list of properties and looks at the description of the rights that are granted to Miss Mansour, beginning about halfway down, it says the attorney has the right to receive and collect money, etc. Could I ask Your Lordship just to read that to yourself now? And it goes over the page as well, or at least skim it.
Yeah, I've looked at this before.
Yeah, it's incredibly broad. It's giving Miss Mansour the power expressly to dispose of Mr. Rashed's assets, including what can only be valuable properties, and she's entitled to dispose of them, execute contracts of sale in respect of them, and hold the monies, collect the price in respect of them. So she's entitled to hang on to the proceeds of these sales. And then the point that Your Honour picked up earlier, when was this document executed? Well, 3 or 4 months after Your Honour made a freezing order preventing Mr. Rashed from dissipating or disposing of any of his assets. It was executed on the 2nd of May, 2025. So we say that this could not be clearer evidence that both Miss Mansour and RBM have been authorised by Mr. Rashed to take control of and dispose of his property, including extensive portfolios of properties that hitherto we hadn't even known existed or were registered in Mr. Rashed's name. And then, of course, in light of the fact that we'd found this, it obviously cried out for a very good explanation. But Your Honour saw that the totality of the evidence in response to it was this is no longer relevant because it was inadvertently overlooked and now has been revoked and is no longer in effect. Well, we say that's just completely implausible in light of the broad powers that have been given to Miss Mansour under this. And even then, if Your Honour looks at the document by which this power of attorney has purportedly been revoked, it's at page 7121 of the bundle. If Your Honour has that, this is the notice of cancellation of the power of attorney. But even here, we've only been shown by Miss Mansour, as you can see at the bottom, page 1 of 3 of this document. If you go to the next page, it's just the translation of the first page, and then that's it. So in fact, the court hasn't even been provided with the full document that purports to cancel the power of attorney, including an indication of when this document was executed. So Your Honour, this is a really important document from our perspective in my submission, because it answers to a large extent your question about utility. Why freeze the assets of these respondents if the rental proceeds from HMR's properties are potentially not generating significant profits? Well, this power of attorney shows very clearly that we are probably only scratching at the surface of the properties which Mr. Rashed owns and which might be available for enforcement. They are both Miss Mansour in her capacity as attorney and Mr. Rashed are continuing to both collect rental proceeds without us knowing, and dealing with properties in breach of your freezing order.
What date is this revocations? I can't quite see a revocation date.
It's not on there. It's not been exhibited to the
Right.
to the statement. We only have page 1 of 3, so we don't know when it was revoked. We also don't know whether one was put in place immediately afterwards on identical terms.
But quite critically, from the overall perspective in this case, we have 3 properties here in the DIFC that are owned by the defendant.
That are on the face of it owned by the defendant, amenable to execution, which Miss Mansour has been given the power to deal with or dispose of.
Yeah.
In my submission, there almost could not be a clearer case for Chabra protection in those circumstances. And against all this, Your Honour has to have in mind the point that none of this has come from disclosure, which Your Honour has ordered. So when we talk about the utility of perhaps making further disclosure orders at the expense of getting rid of the freezing orders, in my submission, Your Honour should bear in mind that there does not appear to be any incentive on these parties to comply with disclosure orders properly, whether wholesale in the case of Mr. Rashed or through omissions such as this in the case of Miss Mansour. And the freezing orders we're seeking today go hand in hand essentially with the freezing orders you made in February of last year. And this is clear evidence that the enforcement principle is satisfied on these facts.
Yes.
So just 2 final points then, Your Honour. The first is the checks. Now, I've taken you to the point that Ms. Mansour made about RBM not having more than $10,000 in its bank and having not received any monies from HMR. Can I ask you please to turn up page 7164 of the bundle? And just while Your Honour is getting that, what you will find is an email from one of the tenants of the Polo Residence building to the new managers that have been appointed by GTC's agent to manage these properties. And it's an email from a tenant to the agent called Continental, and it says, please find attached the following.
Could you just, sorry to interrupt, could you just give me the page reference? I thought it was 7164. That was the one you gave, but it doesn't seem to be the right reference.
What does my learned friend have?
Which section is it in?
It will be one of the very later sections. It had also been AK, Your Honour, as part of Exhibit KAB 10.
Right.
My 7164 is KAB 10, page 7, if that helps.
It may be a couple of pages before or afterwards then. The email which has the attachments is 7164.
Is it an email dated the 2nd of September?
Yes.
I think it appears in the bundle, my bundle, 7162. I'm not on the case line. I'm on the PDF bundle, not the case lines bundle.
I'm also on the PDF bundle, oddly, but
it's
not sure.
KAB 10, page 5.
Yes, that's yes. KAB page 5. I'm grateful to my learned friend. It's KAB 10, page 5. The email itself not as important, Your Honour, but does Your Honour have it?
Yes, this 2nd September 2024, enclosing 4 checks.
Yes, exactly, and a tenant contract information certificate. So if you then turn the page to the attachments, just briefly noting in the tenant contract information that FAM Real Estate are still listed as the property managers, notwithstanding that they are no longer acting in that capacity. But then can Your Honour turn up the 4 checks which are attached?
Hold on. The email at 2nd of September is sent to whom?
That is sent to Continental, who are the new property managers for the Polo Residence building, who have been installed by the claimant.
Okay, fine. Yeah, and the checks are payable to RBM.
Yes, in the cover email, they're described as checks issued to the owner, quote unquote, is what's said in the tenant's email. 3 of them are issued to RBM. One dated as recently as the 20th of August 2024, for an amount that is just under $9,000 US. I think it's about $8,700 US is 32,000 dirham. So very close to the limit of the disclosure order. And then 1 check to FAM Real Estate as well.
Yeah.
So we say it's inconceivable that Miss Mansour is not aware of this, and that it is clear evidence that RBM is receiving rental proceeds, notwithstanding whatever the balance sheet position is of HMR. It's receiving proceeds from the properties that are held by it, and also it must, in my submission, undermine the evidence given by Miss Mansour that there isn't $10,000 in the bank account, because this is very close to it. And my lord, I just have one more point to finish, if I may. And this is the point about Mr. Rashed, or at least somebody acting on his behalf, sending legal notices which are directly contrary to your lordship's sale order of January, insofar as they describe Mr. Rashed as the owner of HMR and the properties. What essentially has happened, this is described in Mr. Bassiso's 2 most recent affidavits, but what has essentially happened is that the claimant in the middle of August was served with a legal notice from Mr. Rashed, in which Mr. Rashed describes himself as the 100% owner of the shares in HMR, notwithstanding the terms of your order of sale. The page reference for that is 7012, for your note, Your Honour.
Yeah.
You see ownership of shares. Mr. Rashed is the sole owner of all shares of HMR Investment Holding Limited. Well, certainly not as a matter of DIFC law, he's not, and pursuant to the terms of your order. But then more concerningly than the claimant having received this is that the same document was sent to Continental, the new property managers, by way of an email from an unknown email address, or at least an email address we haven't seen before. That's at page 7160 of the bundle, Your Honour.
Yeah.
It's from an email called hmrproperty.com. and it says attached, please find attached legal notice. It's not been exhibited for reasons of page numbers, but it's the same document that we just saw was attached to this email, sent on the 30th of August by HMR Property. What Mr. Basiso has managed to work out very cleverly is that that domain name for that email address was created on the 18th of July 2024, and you can see that on page 7163. And what has happened since then is that this email address, which was recently created, sent an email to not only the Continental as the managers, but also to individual tenants as well. And you can see that at page 7161. An email from this HMR Property domain name saying, "We, the owners of Polo and HMR, reiterate that we have not hired any new management company." And what the email is essentially doing is attempting to interfere with the tenant's ability to deal properly with the new agents that have been appointed through the claimant in respect of the Polo residence properties. So I highlight that, Your Honour, simply to show that this consistent attempt to stymie Your Honour's orders and the orders of this court, I'm afraid, continues unabated. And in circumstances where Miss Mansour has a legal power of attorney and has, by her own admission, been closely involved in the conduct of litigation, both onshore and in the DIFC, on behalf of Mr. Rashed, we say it's just simply inconceivable that she's not aware of this correspondence, which seeks expressly to undermine the efficacy of your rulings and this court's rulings, and it's just another reason why her evidence ought to be treated with caution. So, Judge, as you mentioned, I don't intend to deal with any of the full and frank disclosure points. Could I be permitted the equivalent of Mr. Patrick Joyce's 2 minutes, but I will keep it to 2 minutes, just to double check that there are no further points from my instructing solicitors. But otherwise, Your Honour, unless you have any further questions, those are my submissions.
Thank you. Yes, all right. We'll just take instructions as you need. Thank you.
I have already taken instructions, and there are no further points. So I'm grateful.
Right. Yes.
Your Honour, there is a great danger of my learned friend attempting to create the expression which comes to mind is guilt by association. But obviously that's not absolutely accurate, but it conveys the impression that I wish to convey. The learned friend raises matters, the last one being a prime example of matters originating from Mr. Rashed and seeking to bring in, by simple dint of the fact that she worked for Mr. Rashed for a number of years, my client. No other basis for an association put forward on behalf of the claimant other than the fact that she had worked for him for a number of years. Your Honour, I don't need really to put the point down with an experienced court like this, but it does need to be said, if only because my client is here and would wish it to be said on the record. This is not appropriate for seeking to deprive her of her wherewithal for living. And it really is not something that should be brooked or countenanced. Let me turn to the checks because there is an over-enthusiasm to deny the third respondent and her company the benefit of the doubt at every turn. This is a particularly good example. The evidence was provided by the fifth witness statement of Mr. Basiso, which is dated the 10th of September. So a matter of just a couple of clear days ago. The material which he seeks to rely on in relation to the checks was provided to Continental, the new managing agents, so readily accessible to the claimant on the 2nd of September. We know that from KAB 10, page 5, which is on page 7162 or 7164, depending on which version of the final bundle one's working off. So there was really a waiting of 8 days before evidence saw the light of day, rather similar to the extensive delay which I have brought and placed before the court in relation to the service of the documents of the freezing order when it had been obtained on the ex parte hearing. But it actually goes further than that. Because if one looks at this email of the 2nd of September, what one is told is the tenant contract information registration certificate issued on the 13th of February 2024, showing the start date of the 15th of December 2023, with an end date of the 14th of December 2024. And the checks are on the first date of the tenancy year-long agreement, then seemingly on the first quarter day, the second quarter day, yes, sorry, not quarter days, third days. It's trimestral. So after the first trimester, the second trimester, and I think it's probably a misdating at the end of the year-long contract. Now, Your Honour, I think it is a matter of notorious knowledge, and therefore something of which judicial notice can be taken, that in Dubai, for rental agreements, post-dated checks are habitually taken at the beginning of the contract period on periodic bases, whether it's quarter days or
we can see that from page 7168.
We can.
Receipt was the 21st of December for checks.
That is correct. And therefore, this is all post-dated, and the suggestion that funds were being channeled to Royal Business Management after the knowledge on the part of my client of her removal as company secretary just is not made out. She did not know that she had been removed as company secretary until the 23rd of April 2024. She says that in her first or second, sorry, I think it's the second affidavit. So it's certainly towards the end of April 2024. So the fact that she receives post-dated checks in December 2023 in her capacity as company secretary is, in my submission, not at all surprising. And therefore, had the learned friend not sought to store this up until a couple of days beforehand, it could have been answered much more easily and just as comprehensively. Let me go back to various of the points raised, and some of them fade into insignificance as we go through. The point about the term traceability, Your Lordship, Your Honour was kind enough to recognise that it was in fact a court term rather than my term. question about what was the assets of RBM and what RBM was asked to disclose. If your Honour looks at the terms of the disclosure order 4707 at 4710, the terms, we looked at this when I was making my submissions, but it's to be found at paragraph 3 so far as royalty business management is concerned, page 4710. Total sums received since 2019 from and on behalf of the second defendant, from FAM, and in addition from any third party which paid sums to royalty business management in respect to properties owned by or registered by the second defendant. Now, what that asks for is details of the payment of sums. And that is precisely what my client sought to provide by providing the service charges and by investigating, by going back to the accounts which had been provided as exhibits to Mr. Basiso's fourth witness statement and analysing those. She has, as is clear from the record, she has been removed from being company secretary since April. She is subject to a worldwide freezing order, which severely limits her ability to function. She worked with the material which she had and which she was able to provide. If one looks at it this way, she is not like the first defendant who has sought not to be cooperative with the court. She has provided three affidavits. She's provided disclosure of her means in the first affidavit. She's built on that by exhibiting it to her second affidavit and expanding information. I'll come back to the accounts in 2022. And she has responded at each and every turn to everything that has been put to her in the evidence of Mr. Basiso. To suggest that she should have provided something which wasn't asked for in the disclosure order is to miss the point. What was required and expected and delivered on behalf of RBM and Ms. Mansour was a response to the disclosure order in the terms in which it was provided. And it really doesn't lie in my learned friend's remit to say that other material, such as bank statements, should have been provided when what was required and requested was sums where evidence has been provided in that regard. My learned friend spoke about the first defendant's status as an unpurged contemnor and said that he wasn't doing this really gratuitously, I think was his word. But once again, rather as we saw at the end of his submissions, so towards the beginning of his submissions, his case is mounted on a basis of guilt by proxy, tarring Ms. Mansour with the same brush as Mr. Rashed. And as we saw from 4VVV, although it's straightforward and one doesn't really need authority in support of the proposition, you simply cannot obtain freezing orders against parties on that basis. Guilt by proxy, tarring with the same brush. It has to be specific. And that's why I took the court back to what was said and what the evidence was when the application was made and the injunction was granted. And in my submission, there is no further evidence which is advanced in that regard. And to make that point good, if one looks at you get the one looks at Lacatamia at paragraph 7, paragraph 7, which is at page 4591 in the bundle. Paragraph 3, which I said the court was not taken to first time round, and it was not taken to this time round, because my learned friend limited his submissions to paragraph 7.1 of what Mr. Justice Popplewell had said. Paragraph 7.3 makes it very clear. In such cases, the jurisdiction will be exercised where it is just and convenient to do so. The jurisdiction is exceptional, should be exercised with caution, taking care that it should not operate oppressively to innocent third parties who are not substantive defendants and have not acted to frustrate the administration of justice. In my submission, that's apt to describe Ms. Mansour, certainly not apt to describe Mr. Rashed, and that is precisely why one cannot have guilt by association. And my learned friend then, using the same passage, talks about the need only for the availability of some process. I accept that that is what the wording says, but the thrust of my learned friend's submission is essentially to say that a Micawberish approach is satisfactory. As long as something will turn up in the end, then we can get a worldwide freezing order in the interim. Your Honour, in my submission, that is not the way in which the court should approach it, because the court must, in my submission, look for some for some process which is, if you like, a reasonable process rather than a fanciful process, to take the test from summary or immediate judgment. And that is why going to finding out what is the position so far as the Dubai court is concerned is in our submission important, because if there is no means of securing of executing against assets in the DIFC against Mr. Rashed, then it is Micawberism to say that there should be a freezing order against Ms. Mansour and her company in the support of something which cannot in any event be obtained. So if the process is shown to be leading down a blind alley, which in our submission this is, then that is not some process for the purpose of satisfying the Lacatamia test. My learned friend did invite me to withdraw a statement that I made that the court hadn't been reminded at first instance, or the original application. The court hadn't been reminded in the original application that it needed to exercise its jurisdiction with caution. I wasn't there, but my submission, and in particular, the absence of drawing attention to paragraph 7.3 was made on the basis of what I'd read. I could see that reference had been made to 7.1, but not to the full extent of 7.3, which I've now had an opportunity to draw the court's attention to. The next point.
I hesitate to interrupt my learned friend. Is his position that that paragraph was expressly drawn to the court because it was, and I can give the court the transcript reference where Mr. Holloway read that.
I have read the transcript as well, and I can provide the transcript reference.
I'm grateful for my information.
I am not going behind the transcript. I am relying on the transcript for what I could see, the extent to which the court was taken to the passage and the extent to which the court was not taken to the passage. But if it assists my learned friend, the question of approaching a worldwide freezing order with caution is something which is pretty commonplace with regard to worldwide freezing orders, and therefore whether it was or was not drawn to the court's particular attention, I'm sure the court would have that in mind. My concern was that the full text from paragraph 7.3 I could not see had been drawn to the court's attention, and it's that paragraph.
I feel obliged to step in on Mr. Holloway's behalf on this, because I think these submissions are unfair in light of what the transcript expressly says. It's page 7077 to 7078.
Yes.
And Mr. Holloway very properly took you to the entirety of that test, and he read out the parts of the judgment in Lackatamia, which my learned friend said in his skeleton, Mr. Holloway had not drawn your attention to. So I feel obliged on Mr. Holloway's behalf to point that out, because in my submission, these submissions are not fair.
Well, I've got all that on board.
No, it's my misreading. I thought there was more to 7.3. I accept my learned friend's point. He is correct. I withdraw that point. And my apologies for having detained the court on that. It's a bad point. Let me move on. The next point that my learned friend made was that, let me see. Yes, he took the court to the 2017 accounts at, I can give you the page references, but the court will recall it, the 2017 accounts in relation to HMR, and the timing of a change of bank account, which he said contradicted Ms. Mansour's assertion in relation to sanctions. Ms. Mansour gives evidence, or gave evidence, of the change at two distinct points in her evidence. The first point was in paragraph 21 of her first affidavit, where she said simply that the companies, and that's both D2 and R1, so HMR and Royal View, the company's accounts were closed in 2019 at the bank's request, owing to the bank sanction policy. So at that point, it's simply 2019. It is correct that in paragraph paragraph 33B of her second affidavit, which is on page 6414, she is a little bit more specific and says that R1 has not maintained any bank account since the closure of its accounts in early 2019. Now, there is no more specificity with regard to the date than that, but in my submission, it's not unreasonable for her evidence to be taken as indicating a closure in 2019. And in any event, this is a transfer of banking arrangements between R1 and 2 because of the closure of both of the bank accounts of R1 and D2. So that in our submission, this goes perhaps more to the second respondent rather than to the third respondent, Ms. Mansour. The evidence is, again, let me see, my apologies. Yes. Yes, my learned friend made submissions or submitted that there was evidence of a sale of evidences. Sorry, there was evidence of leases continuing to be registered after the court had made its sale order in mid-February 2024. And my learned friend prayed in aid the execution of leases at the end of March 2024. But that is, and that was evidence before the court at the ex parte hearing, and is prayed in aid again by my learned friend. The point that I would draw the court's attention to is a point that I drew the court's attention to previously, but it's at paragraph 24E of Ms. Mansour's second affidavit, which identifies the precise date as to when she was, or a date on which she was still labouring under the misapprehension that her position as company secretary had not changed. 24E reads, I was not informed of any change in my position as company secretary prior to my witness statement dated the 23rd of April 2024. So once again,
how can that be? How can that actually be, Mr. Patrick Joyce? She's running this litigation for D1 and D2.
She is running this litigation for D1 and D2. I cannot.
She must have known following the January hearings, mustn't she?
I don't think she was in attendance at the January hearing.
No.
My learned friend says that the solicitors then on the record would have drawn that to her attention. Oh. I cannot go behind what she says in her evidence.
Well, I understand that. I'm simply asking how that could possibly be. It would imply that Charles Russell's speeches simply didn't inform her of the results, which, you know, is a surprising proposition.
It's not a proposition that I would wish to support, but nor can I go behind what Ms. Mansour says in this paragraph. And of course, the interesting thing about this paragraph is that it isn't directed to the point that it isn't directed to when leases were entered into or not.
No.
It's simply a recitation, a factual recitation of her position. So if one looks at paragraph 24 and the subparagraphs, she talks about her power of attorney. She talks about a specific matter in 24B. She talks about her position as company secretary and her role as company secretary. It's entirely factual. And there's absolutely no reason in my submission why she would not be true and accurate in an entirely factual recitation in this context. It just makes no sense for that to be the case. So in my submission, there are strong grounds for accepting her evidence because of the context in which the evidence is given. But I can't take that point further, Your Honour, but that is what I would say in relation to her date of knowledge.
Yeah.
The next point is in relation to the royalty business management records, which were produced by Mr. Basiso as an exhibit to his fourth witness statement. It begins at page 4411, and indeed it might be helpful just to turn up 4411. Let me do the same. Yes, and on this page, one can see about perhaps 10 lines down, there are three entries for the 23rd of December. And if one looks at the middle entry, that's a reference to Al-Fatan 1501, rental income.
Yeah.
Now, this, in my submission, is a good example of where the claimant is putting 2 and 2 together and getting 5. Because the evidence was that when Mr. Basiso came to serve papers on Mr. Rashed, he went either to floor 5 or floor 50. But the numbering of this flat is 1501. There is no evidence at all that this is the first defendant's property, and it is an example in my submission of other properties being administered by RBM. It's simply because there is an indication that Mr. Rashed had other properties in Al-Fatan does not mean that this is one of those properties, does not mean that this has anything to do with Miss Mansour and her knowledge of Mr. Rashed. The significant sums which were said to have been paid to Miss Mansour were, in my submission, salary, and the larger payments were unexplained to the court, or the explanation was unclear to the court when the matter was brought before the court on the ex parte hearing in May. And in this regard, one needs to look at the transcript at page 7061. Uh, 7061 is where the court, where the submissions relate to the larger payments, foot of that page. Then the court points out that operational expenses was given as an explanation. Then there is confusion in the middle of that page as to whether a payment was to whom a payment was being made. It wasn't being made to Miss Mansour, it was being made apparently to her father. Then the court says at the foot of that page, you can see salary payments. And then there's further confusion, but it looks again to be confirmed as to be a salary to Hala payment in the middle of page 47063. Then going over the page, further salary payments, and then we have salary to Mahmoud, salary to Ashraf, and then there is the boat matter, which I'll come back to, and then further a discussion of the boat payments, the Al-Fatan, which I've dealt with, and then the submissions invite the court to draw an inference at the foot of page 7066. So in essence, or the suggestion that there are a number of larger unexplained payments was fully explored and placed before the court at the ex parte hearing. And when one looks at the evidence, it adds up to really nothing beyond salary being paid to Miss Mansour. My next reference, just no, I've covered that. My learned friend on at a couple of occasions seemed to put his case on the basis that Miss Mansour was a continuing manager of Royal View and had continued in that position and for 13 years from 2011 onwards. If one looks at page 6402 and 6403, I must say I had read her evidence somewhat differently, in that at the foot of page 6402, she deals with Royal View or provides information simply to assist the court, and she explains that it was actively engaged in general trading businesses and in general trading business activities until the year 2019, and then from 2015 until the handover of D2's properties, the first respondent had covered the costs and expenses related to those properties. Going over the page, R1 does not possess any assets and does not owe any payments to D2. In fact, D2 owes R1 a significant amount. So pausing there, that's what she says about Royal View. And it was my understanding that essentially Royal View had then become a shell because of the closure of its bank account for sanctions reasons, and of necessity matters had then transferred to Royalty Business Management. So when my learned friend criticizes Ms. Mansour for not giving an affidavit, a disclosure, for not complying with, sorry, when my learned friend draws the failure of Royal View to make a disclosure order to the court and then seeks to lay that failure at the door of the third respondent, in my submission, that is an inappropriate submission, because her involvement with Royal View was simply as an administrative manager, and that had essentially ceased in 2019, and she has no ongoing, enduring position with that entity. Similarly, when my learned friend seeks to pray and aid the affidavit from FAM Properties, this again is not a matter for either of my clients. They certainly cannot comment or go beyond or indeed comment upon, qualify in any shape or form what is said in that affidavit. My learned friend laid some considerable emphasis on what is said at pages 6932 and 6946. This is in relation to what is cash in hand at Royalty Business Management. These are data as of the 31st of December 2022, and Millennium Friend seeks to establish that there is a real risk of dissipation because of the financial circumstances set out on these pages, and he says that there is cash at hand available to RBM. Of course, the position which is shown on these pages is, as is made clear, as of the 31st of December 2022. That is well over a year and a half ago, and what was the position then is not at all necessarily the position now. And again, Ms. Mansour has given clear evidence in relation to the cash availability so far as RBM's present standing. It is less than 10,000 US dollars.
Your Honour, I hesitate to interrupt my learned friend, but I'm just noticing the time and the fact that...
Yes, I will be very short. I think I've got one or two more points that I need to make.
I'm grateful. I apologise for interrupting.
No, the next point I would make is to come back to the boat, where it was said that there is no that the question mark is raised in relation to the boat because of the boat is not property and is accordingly, so my learned friend says, unexplained. What she says is that it was not her boat. She's never owned a boat. The circumstances of RBM was to act as property managers. Property as real property in terms of bricks and mortar. She has said that it was not property which was the first defendant's, and again it falls into the category of Alpha Tan, the Alpha Tan property, another example of RBM carrying out business which was separate and distinct from D1, D2, or R1. There were a number of points which I had to deal with. I'm sorry that they were a little bit staccato in my response, but I needed to recall each and every instance. Could I again have 2 minutes just to check that I've covered the points that those in Dubai would wish me to have covered?
Yes, of course.
I'm obliged.
My lord, whilst my learned friend is doing that, I did just want to flag that I had one very short 30-second point that I wished to raise, which I had forgotten to put on the end of my submissions. If I could just raise that at some point before the end of the hearing.
Yes, thank you.
Your Honour, I'm obliged. There is one point that I should raise because I'm asked to raise it. I have no evidence in support of it, so I raise it with due circumspection. But the change in the license, whereby Ms. Mansour was removed as company secretary, it would certainly have been information which would have been provided to Millennium Friends instructing solicitors, but because it affected, because it was on the basis of an application for the order, following through on the order of sale, I am not certain as to who beyond the claimant solicitors were notified. I don't wish to take it any further short of instructions, save that I am clearly instructed that my client, Ms. Mansour, only knew about it on the 25th of April 2024. So whatever the circumstances were which prevented her from knowing until then, that date is clear and clear on instructions. She did not know until that date.
Yes, thank you. While you were away taking instructions, Mr. Anderson told me that he wanted to make one further point, which,
right, yes.
Which I assume he will now make in your presence.
Yes, I'm grateful. It's a very short one. It's something I didn't address you on in my main submissions, which relates to the balance of convenience. Just to flag the point, if Your Honour doesn't have it in mind already, that although it is said that obviously these freezing orders are operating to great oppression to both Ms. Mansour and RBM, Your Honour will recall that both freezing orders include the usual carve out for ordinary living expenses up to $10,000 a month, and a reasonable sum on legal advice and representation. I made the point earlier that there was the obligation to notify us as to where those sums would come from. We've not received any such notification from either Ms. Mansour or RBM. But also, of course, in relation to the point that these orders are stymieing or frustrating RBM's business, it's always been open to RBM to either write to my instructing solicitors or apply to the courts to introduce an ordinary, proper and course of business exception. But we've not heard anything from Ms. Mansour or RBM solicitors to that effect, nor have we heard anything in relation to increasing the spending limits in relation to legal fees or living expenses. So I just wanted to make that point clear in the context of the balance of convenience.
Yes, all right, thank you. Do you want to say anything, Mr. Patrick Joyce, about that?
No, the point remains valid, that it's causing great inconvenience and harm to my client.
Yeah. All right. Well, we're pretty late now so far as Dubai is concerned. I shall reserve judgment, and I'll let you have it just as soon as I can. Thank you all very much, and thank you particularly to the court staff for staying late on a Friday night.
Indeed.
So if you would kindly sign out and just let me have a word with the court staff, that would be very helpful. Thank you.
I'm obliged, Your Honour.
Your Honour, just before we do, I won't go through it now, but we had the question of costs on those initial applications. Will that be dealt with in your judgment, or will you invite us to put in written submissions, or what's the plan?
Well, I think it can, as long as you don't lose sight of it, it can wait the judgment that I give here. The judgment that I give here and the result of that, and we can deal with costs all at the same time in relation to all matters as and when.
I'm grateful.
All
I
right.
just want to check
No, thank you very much. Thank you.